এই দেবজি দিকে না একটু কাছে আনা। হ্যাঁ শোন না, এটা সাউন্ডটা এখন কি ওরা বন্ধ করে রেখেছে বলে শুনতে পাচ্ছি না, কারণ মেনশনিং হচ্ছে, এটা তো আমার নিজস্ব, ঠিক আছে, কিন্তু তোর কোথাও সাউন্ড তো অন আছে। হ্যাঁ না পাচ্ছি না।
হ্যাঁ তাহলে মনে হয় ওরা
হওয়ার পরে
18, my lord, I am appearing for the petitioner led by Mr. Unauthorized. Petitioners are essentially seeking for redressal in the light of a judgment passed by your lordship on 30th September 2022, which has been carried into appeal first before the Honorable Division Bench and then before the Honorable Supreme Court. The SLP has been disposed of, but one modification application is still pending, lordship. In view, as per my...
Come back, I'll just
Ye-
adjourn the matter for some.
Yes, lordship.
My lord, I am appearing on behalf of Bardhaman Development.
Mr. Dey is appearing in for this. So there's an SLP, I think, before the Honorable Supreme Court. Mr.
SLP
Dey,
disposed, but one modification application.
SLP number down.
on prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 15th May should be sufficient. 15th May. Next.
This is my application, my lord. May please, lordship, my lord. My affidavit.
Respondents.
My lord, I am
It has agreement. I have served all, my lord. And what happens, my lord? Petitioners are owners of certain lands in question, my lord. I have stated that in paragraph.
Have you served the Jela Parishad?
Yes, I have served all, my lord.
All of them?
Paragraph 2 and 3. Now, my lord.
Where is the service on Jela Parishad?
Jela Parishad ki dini? By post. দেখতে দিচ্ছি extra copy আছে
Yes, they've received.
they receive, my lord.
By
But
hand.
what happens, my lord, for the purpose of construction of Katwa jetty ghat, these lands are being totally utilized, my lord. And my lord, and one LA case was started initially, my lord, in Act 2, my lord. That is a case I've stated that in paragraph 3, LA case number 31R 8283. Now, my lord, then that so far as Act 2 is concerned, the justice knows what happens in Act 2. What happens in a similarly placed persons, my lord, I have stated that when my lord, kindly come to page 6, paragraph 9.
Yes.
And Ananda Gopal Shaha, he is also a owner of plot number 2197. 2197 and 2174 are two of the plots, my lord, our plots. He is one of a part portion of 2197, my lord. 2179, sorry. And he moved up to, my lord, almost division bench, my lord, up to and got compensation. And by virtue of purchase, I have already annexed, my lord, paragraph annexed P4, page 27 is the order of division bench. And my lord, the sale deed at page 30. But by way of purchase, some of rupees 20,082, 20 lakhs 82,703. That was the purchase value, my lord. So, my lord, I am only, my lord, praying for similarly treatment should be given to my client, my lord. This is my humble prayer, my lord. I made my representations, lots of representations are there. Final representation at page 45, na? Annexure P5, my lord, at page 51. That has not been considered also. I have, in that representation, I have made reference to the order of Ananda Gopal Shah, similarly placed, my lord.
This is a demand of justice. This is not a representation.
Demand of justice, yes.
Where is
Demand.
your representation?
But representation, my lord, earlier, my lord, I have stated that. My lord, can you treat that also? Representation এখানে আছে হ্যাঁ বাংলা এগুলো and at page 23 given by my power of attorney holder annexure P3 as page 20 and 23 Yes. There are two representations dated 27th of March 2023 and another at 24th of April 2023.
28th of April.
At page 23, 28 of. My only case is, my lord, by similarly placed person, they got compensation by direct purchase, my lord. Same plot of land, same LA case. Only, my lord, the portion is different. Same treatment maybe given to the petitioner also.
Where is the earlier order of the coordinate bench?
My lord. Earlier order I have not
Because
annexed.
since
My
you
lord.
say that the
Yes.
petitioners are similarly
Yes,
situated.
my lord, earlier order, my lord, I have not annexed. I have added order. I have annexed the order of the division bench
The
at page 20.
facts are not clear from the division bench's order.
Facts are not clear, but kindly come to my lord.
Division bench order only says that the order has been complied with.
But kindly come to the deed itself. In the deed itself, at page 32, my lord, it has been written, my lord. Details has been given, and whereas as per provisions of section 4 at page 2, same LA case bearing number such and such, publishing the project of construction of Katawak dedicated in such and such.
Here also the division bench matter, the MAT has been referred to, not
But
the single bench order.
No, my lord,
Where is the single bench order?
single bench order বার করতে পারবি চট করে?
You don't
Number is there, my lord.
One thing, my lord. Previous occasion, my lord, as per previous order, my lord, department has proceed the matter and generate the fund. My lord, kindly have a
Double bit
look
over.
this, my lord.
So these petitioners are similarly circumstanced?
No, I don't know, my lord. As per my lord, previous same dag number is same, my lord, 2179.
And 7-4.
And my lord, we proceed the same, my lord, previous, my lord, kindly, this is the chart.
বার করতে পারবি অর্ডারটা? হচ্ছে।
2179 and 2174. These are the petitioners.
My lord.
plans.
Total 5 decibel, my lord.
2174 acquired area is 0.02 acres.
Right.
And 21
Yes. That I have received.
it is
That I have received from my lord, information at page 19. RTI information. Paragraph, annexure P2. Special land acquisition correct officer, Purva Bardhaman.
So the
2179.
authority says that in 2179 compensation has been paid.
No, 2179. No. As per 2175.
79.
7.
74 and 79. These are your plots.
No. Kindly come to my page 19B. Page 19B. 2175, 2176,
Okay.
2177, and 2184 has been paid. Not 2179 and 2174. These are reply to RTI, my RTI.
In order to find out whether you stand on the same footing, the single bench order is required.
Single order,
Because that will have the details of the plot numbers and the shares.
my lord is absolutely right, my lord. Then, my lord, kindly fix this matter on any day, my lord. I'll get it today.
Will you take instructions in the meantime?
Yes, my lord.
Because your
thought-
instructions are not in sync with the RTI reply. Your instructions
Huh?
say that for plot number 2179, it has been paid. RTI reply says it is not paid.
Not paid.
No, my lord, kindly, my lord, my instruction, my lord, estimate, my lord, this is the last paragraph, second page, my lord, in my instruction, the estimated which has prepared as per provision so and so, my lord, the preview guideline of the department comes as on my lord, 70 lakhs, 3,000, my lord, so and so was sent to the LR and LR department, West Bengal, for getting necessary approval. The memo number so and so, this said estimate was approved by the department, was communicated to the end of memo so and so on. Accordingly, the requiring body is requested for placement of fund so and so, and on receiving of the requiring fund from the end of so and so, the proceedings of the payment compensation to the land loser will be taken up as per government norms.
At page 28, my lord.
My lord, we are, my lord, thorough check this paper, my lord, he is entitled, he got it.
No, fine.
So please come back with definite instructions.
And at page 28 of the division bench order, my lord, disbursement of the amount of rupees 86 lakh 28,329 in favor of the land losers petitions to file a report before this court with regard to this. Kindly see the first paragraph at page 28. So, my lord, money is there, my lord, only.
Respondent, these petitioners are similarly placed with the
Same.
petitioners of the earlier. That has to be seen from the single bench order.
That my lord,
Demonstrate
pages.
Do you have a copy of the coordinate?
It will take some. I thought, my lord, only division will suffice, my lord, because
It doesn't say much.
as my lord, same LA case has been reflects from the deed itself. Reflections to the same LA case is there, man. In the deed itself, I thought, my lord, that division.
The LA case number also doesn't appear in the division bench order.
Division bench order, my lord, LA case ache to. LA case ache na? LA case number ache to.
This only says that the order has been complied with.
Bakurajis.
So please
Because,
come
my
back.
lord, we assessed all these DAG numbers and, my lord, to generate a fund.
Please take this back.
Mal.
Come back with a comprehensive report.
Kindly keep a short date, my lord. Day after
Short date after May, because I'll be in the circuit bench in the meantime.
After May.
In May.
This month.
Of service.
This month, my lord, after.
চলে যান দেখুন আমরা টাকা জেনারেট করে দিচ্ছি বুঝেছো
Affidavit of service.
হ্যাঁ হ্যাঁ 1.70 lakh.
Learned friend is telling that money has been generated already.
Yes.
My learned friend is telling that money has already been generated.
Pay it in the meantime.
Whether he is entitled or not, my lord, if he entitled, my lord, we shall pay. We have no difficulties. Whoever may be, my lord, we are verifying the documents.
Order, I could have disposed it.
Only that is a difficult. At present, I do not have a copy of that. Only if that is the case, kindly keep it a day after tomorrow. I'll come.
Not possible, sir.
2 p.m. my lord.
Let the matter appear under the same heading for further consideration.
Kindly keep it after a fortnight. My lord, কবে থাকছেন না? কবে থেকে থাকছেন না?
7th May.
7th May, my lord. Cannot be.
I have said just now, I'll be in the circuit bench for the last
next 2 weeks.
On 22nd. Next.
I'll come with that order, my lord.
Yes. At a line করুন,
আমার খেয়াল হয়নি ওটা।
submit a report in the form of affidavit in this one.
Kindly there be some observation. If said that they are already ready with the money, my lord. If that be the case, my lord, if I am entitled, let them pay in the meantime, my lord.
Come back with the comprehensive report. If you're entitled, you'll definitely be allowed.
Yes.
Be given. Next matter. 20.
Deeply applied, my lord. Well, I am for the private respondent, my lord. Before my lord, if it starts, my lord, may I submit one thing, my lord. There is a case and counter case. My case is, my lord, is at item number 325. My lord, subject to lordship's kind consideration, my lord. Let both the matter be taken up together, because, my lord, there is a civil suit pending. Nothing has been disclosed. In my writ petition, I have disclosed everything, my lord. There is an interim order. And the commissioner was directed to submit a report. Commissioner submitted report. So, my lord, all these, my lord, can be, my lord, useful, my lord, for adjudication of both the writ petitions.
Sir, it is alleged construction on PWD land.
Yes,
state.
but my lord, the commissioner
So
report,
civil suit cannot be on with regard to
Yes,
PWD land.
that is my lord, court directed for the commissioner to submit a report. Commissioner submit a report, there is no whisper that it is on government land. That is my, his commission report is my lord,
The state will be the best person to see.
Yes, my lord. That is, my lord, if your lordship will see this, that is happened. 10-2 notice has already given to the SDO, my lord, to take appropriate action.
PWD land.
Yes, my
Section 10 notice has been issued.
lord. N1 and 10-2, N1 is filed. After that, 10-2 notice was given to the SDO for taking 10-3.
So it's pending for 10-3 compliance.
then my lord, in
Can
that,
this be disposed of?
yes, that bit is for my lord, only one direction is required, my lord. Since my lord, a civil suit pending, a commissioner,
Civil suit cannot be maintainable on government land.
yes, my lord, civil suit non-maintainable, but my lord, that is, I know, my lord, civil suit, my lord, cannot be, my lord, taken into consideration when it is a government land. Provided, my lord, it is a government land. It is required to be incurred into. In that event, my lord, there are commissioner, my lord, duly appointed by the civil court, my lord, be taken note of by the authorities, my lord, at the time of, my lord, adjudication of the dispute.
Given an opportunity of hearing before the authority, you can place all relevant
My lord,
documents.
my lord.
Right?
My lord, the commissioner cannot be the appropriate authority, my lord. The appropriate authority is, my lord, the PWD authority. He is a private
I'll pass
commissioner
necessary
appointed by the
orders.
court, my lord.
Don't
He
worry,
cannot
I will
ascertain,
pass
my lord,
necessary
whether the
orders.
My lord, commissioner report, my lord, where it stated, my lord, it is not on government road, my lord, was not disputed by my lord and client.
Place your
this is
documents.
an unauthorized construction over a public land, my lord. That cannot be subject matter of a suit, my.
Affidavit of service. Heard learned counsels for the parties. Affidavit of service filed by the petitioner and report submitted by the state respondents are taken on record. Therefore, heard learned counsels for the parties. Paragraph: the petitioner claims to be the recorded owner of the plotting question and submits that the private respondent has raised unauthorized construction by encroaching upon PWD land adjoining his property, thereby obstructing his egress and ingress. The petitioner submitted a representation before the concerned authority
আপনি দুটো চলে এসেছে একটা
on 27th April 2023 and prays for a direction upon the authority to consider the representation at the earliest. In this regard,
My lord, now respondent number 3, my lord.
yes,
Respondent number 3 will consider.
learned counsel for the state respondents placing reliance on the report submitted by the assistant engineer, Tomluk Highway Subdivision, Public Works within bracket roads bracket closed directorate on 22nd January 2024, learned counsel for the state respondents submits that it was found upon demarcation of the plot in question by the Block Land and Land Reforms Officer, Tomluk-Roman 1, Purbo Medinipur, that one Asma Bibi, Asma, ASMA, Asma Bibi, private respondent hearing, has raised unauthorized construction of a tile shed room on government land as a result of which the ingress and egress of the petitioner has become narrow. Proceeding has been initiated under Section 10 of the West Bengal Highways Act 1964. Which is pending before the subdivisional magistrate, Tomlu, upon compliance with Section 10(1) and Section 10(2) of the Act. Paragraph. Learned counsel for the private respondent submits that in a title suit filed by and between the parties before the civil court, comma, it was a report was submitted by the
Commissioner appointed by the court.
commissioner appointed by the court. The effect that the private respondent has not occupied government land or any portion thereof.
No, my lord, I have submitted, my lord, I have with the report, my lord. I have submitted, my lord. There is no, my lord, whisper in the report that the construction was made on the government land.
And there is no whisper in the said report that the private respondent has been is occupying government land. Correct. Be that as it may, comma, since it was found upon demarcation that the private respondent is occupying a portion of the PWD land by raising unauthorized construction there, and also, comma, since proceeding under section 10 of the West Bengal Highways Act 1964 is pending, comma, the concerned authority, comma, being the fifth respondent herein, directed to take the proceeding to its logical conclusion within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including petitioner and the private respondent, comma, in accordance with the law. Disposed of which
My lord, subdivision officer.
Section 10 proceeding?
10-3, my lord. 10-3, 10-1 and 10-2 has already done.
That is done. So this is
10-3, my lord, go there and submit it before the SDO. 1 and 2 has already done, my lord.
third respondent.
Yes, my lord.
Third respondent.
But এটা আমার সঙ্গে মিলছে না কেন?
Sorry.
হ্যাঁ, তাই বলবো।
Yes, next.
Private respondent? Yes. I mean 8. Respondent 8.
Petition.
One.
আমার তো দিয়েছো 20টা।
হ্যাঁ।
Yes.
Lord, I beg to affirm the behalf of the
Shut up.
petitioner.
Your appeal.
Thank you.
Lordship, I'm submitting the affidavit.
Procedural.
of office. In the earlier occasion, Lordship directed to copy upon the municipality, that has also been done. Lordship. Kindly put it.
Is it served?
Lordship.
শান্তনু একটু কাগজ দাও না ব্যস্ত আছে সরি
There is the service on the municipality.
That is also,
Agra municipality?
Lord, there is two,
ও আচ্ছা থ্যাংক ইউ ঠিক
Please show me the service on the municipality. I do not find it.
সার্ভিস দেখা
Lord, there is another affidavit of service. Lord, there is two.
I've given both to you.
I am for respondent number 4, my lord. My senior Taposh Mukherjee
Yes.
out of station, my lord. Kindly not this week.
Respondent number 4. Mr. Dey, you are appearing.
I'm from the state.
So subdivisional officer Agra is state. Respondent number 4. So how is she appearing separately?
And for four.
Where is the service? You have sent it by speed post.
Lordship,
So where is the track report?
put it in the
And this doesn't have any seal of the municipality.
Municipality এখানে কি হলো?
Have you seen the track report, sir? You're just handing it over to the court. Where is the service?
Municipality কি হলো? আর municipal পাঠায় না।
দিদি নামটা দিন
কারণে আছে।
Lord, item has been received.
That means service, or it should be item delivery confirmed. It is received by whom? By the beat office.
Lord, current status, here it is showing item received, Lordship.
Item received doesn't mean delivery. Din to didi ota.
দিয়ে দাও দিদি দাও
Correct. Item received by the SO. That is the office. You are aware, sir, it has to be item delivery confirmed. That is the endorsement that is given when it is delivered. This is item bagged and item received by the same office. Please serve and come. You're only wasting time. Another date is gone. Mr. The service is not complete. Since service upon the 9th respondent is not complete as yet, comma, let the matter stand over till 13th May. Next, only the 9th respondent.
13 minutes
22, 24 and 25, these three are all similar matters, my lord. This is the service of 22. So, the answering respondent is the district magistrate and the highway authority. I've served on them both, my lord.
22 দাও 22 দাও
Mr. Dey, you're appearing in this one for all the respondents. Yes, what is the matter about?
My lord, the matter is, my lord, I am
Take the microphone.
yes, my lord. I am the owner of a certain plot of land. My lord, adjacent to my land, the construction of the Bonga-Chakda highway is going on. Now, my lord, the highway authorities, by moving their alignment, by shifting their alignment towards my land, they have encroached over my land. My lord, the first round of litigation, when I came before this honorable court, the single judge held that my writ petition was not maintainable and dismissed the same. With greatest respect, my lord, I was not given a copy of the report to which I could dispute, my lord. Thereafter, I moved before the division bench, my lord. The division bench held that the matter, there were certain things in my matter for which the division bench transferred the matter.
Remanded it back.
Yes, remanded it back to the district magistrate for conducting a hearing. My lord, the comprehensive hearing was done, my lord, and thereafter the district magistrate passed an order, my lord. The order is that, my lord, this is 38. My lord, the order is at page 66, my lord. Oh, sorry. My lord, 1 second, page 66.
Yes. 66.
My
is an
lord, subject to
advocate's
correction,
letter.
my lord, that was another writ petition, my lord, page 76, my lord. 20634, page 76, my lord.
76, yes.
Yes, my lord. My lord, kindly comes to order dated 15th of March 2022, my lord.
Yes.
Yes. My lord, can I read it out, my lord? Yes, my lord. Also examined the enquiry field report, my lord. From the field enquiry, it appears that WBHDCL has made construction in Mouja Balia jail number such and such beyond their alignment. WBHDCL authority submitted in written statement that only temporary work were executed on the disputed portion of the land without dismantling the structures of the petitioner. So having regard to the facts and circumstances and on the examination of materials on record, the authority is directed to remove the encroachment beyond their alignment within 1 month from the date of this order. Now, my lord, my instruction is till date, no,
They have not removed.
they have not removed, and my lord, the construction was permanent in nature. No temporary construction, my lord, and they have damaged my building to such extent that I cannot even enter my building and continue my work over there, my lord. This is my instruction. Kindly see page 69. I've enclosed a photograph also showing the extent of damage. By using a wooden plank, I have to enter my shop, my lord.
Yes, Mr. De. What are you asking for in the writ petition?
My lord, I am just praying for certain modification of this order to the extent compensation be given to me for the damage caused, and my lord, the implementation of this order.
And before the authority will consider what he wants to.
My lord, we have done, that is not, I want modification, my lord. That is why I've come before you.
We have allowed a modification, I could put one. My lord, he can file an application before the authority. The authority will consider with respect of the.
My lord, the order that has been passed is challenged by me over here.
Why don't you file a further representation before the district magistrate
I have filed, my lord.
on these two grounds?
Yes, my lord, I have filed. They have received it, my lord. Page 77 onwards. I filed a detailed representation, my lord.
My lord, that is the advocate letter.
Yes.
This is a demand of justice. It has to be a representation.
My lord, I'll file, but my lord, if some order is given, my lord, just for the implementation, my lord, that's all.
I'll record your submissions that you have twofold grievances. One is compensation.
Yes.
The other is it's a permanent structure.
Yes.
Right? It has not been removed as yet.
Yes.
I'll record her submission and please, I'll allow you to file a comprehensive representation before the authority. Let them dispose of the representation.
In the petition, my lord, we have stated that the encroachment has not been.
That is the instruction which I got, my lord.
Have you stated, recorded in your writ petition?
No, my lord, that.
Lord, you can file an application. Otherwise, my lord, page 66, my lord, if your lordship will see, that is last part, whatever may be that, you can file an application. মানে ভালোর জন্য তো বলছি আমরা তো তোমাকে ওর ভালোর জন্যই বলে দিচ্ছি সমস্ত কিছু পাবে না হলে তো
Have you stated anywhere that the
No, my lord, that
that has not been
Yes,
stated?
yes.
So why don't you file a comprehensive representation?
Yes, my lord.
Informing the authority that it has not been removed as yet,
My lord.
Firstly, secondly, compensation, and then the permanent or the temporary structure, right?
Compensation, well, damage compensation if you want, you can, otherwise. you
Yes.
can't.
He,
Compensation if we are not getting that the encroachment by the other requiring body, and he will withdraw. This magistrate order was passed to withdraw the dismantle the encroachment at once.
so since she is claiming damage compensation also,
Whatever
so
will
let
be
the
that,
authority
but according
consider,
to- we filed an application before the
let
authority,
the authority
and
consider.
this
Yes.
matter will consider it. বাবা, তোমার ভালোই।
Affidavit of service. Pursuant to an order passed by this court, the district magistrate Nodia, by an order passed on 15th March 2022, held that the WBHDCL has made construction beyond their alignment in a portion of the petitioner's land. Stop. WBHDCL, it is not the observation of the authority. It is just the submission made before the authority that it is temporary.
Yes, it is
The
the
authority has not held it to be temporary.
No.
WBHDCL submitted before the district magistrate that that only temporary work was executed on the disputed portion of the land without dismantling the structures of the petitioner. Stop. The district magistrate, by the order impugned, directed the WBHDCL authority to remove the encroachment beyond their alignment within 1 month from the date of order, and adhere to their alignment at the time of construction work. Paragraph. Learned counsel for the petitioner submits that the encroachment made on the petitioner's land is of permanent nature for which the petitioner is unable to access his building on the said land. Also, the petitioner seeks damage compensation for the damage caused to such encroachment. Stop. Learned counsel submits that the encroachment has not been removed till date. The petitioner seeks to submit a comprehensive representation before the concerned authority, ventilating his grievance and prays for a direction upon the authority to consider the representation at the earliest. Second respondent, Mr. De?
Yes, ma'am.
Paragraph. Learned counsel for the respondents submits that the second respondent be directed to consider the representation in accordance with law. Paragraph. In view of the above, the writ petition is disposed of, directing the second respondent to consider and dispose of the representation submitted by the petitioner, disposed of with liberty to the petitioner, to submit a comprehensive representation before the second respondent within 1 week.
Yes, my lord.
Within 1 week from date. Stop. The second respondent is directed to consider and dispose of the representation within 2 months thereafter. Within 2 months from the date of receipt thereof, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of rejectly.
My lord, 24 and 25 is also similar matters. My lord, this is the same matter, my lord. This is the affidavit of
So they
service.
use let me call one. Please.
Yes, my lord, this is my application, my lord. But the subject matter of the petition, it cropped up since 2005. What happened, my lord? A plot of land, 9 kathas, about
You will take some time because there are two other next two matters are similar to the earlier matter.
Yes, my lord.
So yes, so let me just consider those two matters. I'll come back to you.
now 12:30 is also 12:30 is also knocking.
Similar matters, so just give me 2 minutes.
24, this is the affidavit.
Who is appearing for the state? Mr. Bandapad?
Mr. Awan Banerjee is appearing for this state. He is
24. Let the same order be passed.
Same
The date, order is also the same.
Yes, same. Same respondent, same order. Same respondents.
sleep it.
The date of order is also the same.
Same.
So let the same order be.
Yes, ma'am. 25, ma'am. Affidavit of service.
Affidavit of service. Amla. Did the affidavit of service done? Mr. Bandapad, let the same order be passed. Same order. Yes, we come back to 20.
My lord, a plot of land, more than 9 kathas, was allotted in lying and situated at Kolani in favor of one Srimati Sunanda Goswami. Now, at prior to that, she also obtained another plot of land of 5 kathas at New Alipur. Now, the authority concerned demanded that you have to file the return under the Land Ceiling Act. She submitted return. And proper calculation was there. In Alipur, the said land was utilized. The Land Ceiling Authority, though observed that requirement is not necessary, but the authority concerned, the estate manager, what they did, they struck out 4.5 kathas of land from the 9 kathas. Now, that was challenged before this honorable court. One of the learned coordinate bench of presided over Honorable Justice Maharaj Sinha, when his lordship then was pleased to set aside that vesting order. Thereafter, the land was bifurcated, that 9 kathas land was bifurcated as B1 by 221 and another by B1 by 221A. Now, the issue involved in this writ petition in respect of B-1 by 221. Now, my lord, B-221, that Sunanda Goswami submitted an application before the authority. The deeming provision of the lease deed was there. The authority did nothing. So the document was registered in view of the order passed by the Honorable Justice Bhaskar Bhattacharya in long early. The deed was released. The present petitioners before your lordship submitted the same deed for the mutation. Now thereafter, the matter, 3 times, the matter came before this court. But if your lordship kindly straightway come, here they passed an impugned order.
Petitioners, how are they related to the original lessee?
Original lessee, they are not lessee. They are not at all related with the original lessee. They are submitted application, joint application along with the original lessee. Now the petitioners submitted mutation application on the strength of the deed. Now this, they have passed an impugned order, but this impugned order was passed by violating the observation of the division bench of this honorable court. If your lordship kindly take trouble that Division bench order, Lordship will find at page 84.
Yes.
Division bench, Honorable Justice Arijit Banerjee and Honorable Justice Kaushik Chaudhary. Now, my lord, if your lordship kindly allow to place the division bench order, my lord, since my spectacle has broken, my junior will submit. এখান থেকে পড়ে যাও।
One Srimati Sunanda Goswami, in short, Sunanda, was allotted a plot of land in Kollani measuring about 9 katas and 13 chitaks by government in the year 1963. Possession of the plot was handed over to Sunanda on June 10, 1988. The lease deed was executed on 22nd June 1988, wherein the government of West Bengal was shown as the lessor and Sunanda as the lessee in respect of the plot number B-1 to 21A at Kollani. Stop. However, before such allotment for or making over possession to Sunanda by the government, no clearance was obtained under the Urban Land Ceiling Act. After taking possession, Sunanda applied to the government for transferring 50% of the leasehold land in plot in favor of one Shanti Ranjan Bakchi. Such permission was granted. The deed of transfer was executed. 50% of the leasehold land was transferred to Shanti Ranjan Bakchi. It appears that the remaining 50% of the leasehold land, Sunanda transferred to one Sushanta Kumar Roy and another who were the present petitioners. When the appellants applied for mutating their names in the land records, they were told that the transfer was invalid since the land that Sunanda had purported to transfer to them stood vested in the state under the provisions of the Urban Land Ceiling Act. The present appellants challenged the refusal of the authority to mutate their names by filing WP number 33258W of 2014. Before this court, a learned single judge by an order dated 30th January 2015 directed the estate manager Kollani to consider the mutation application of the present petitioners and pass a reasoned order thereon. Pursuant to such order, the estate manager passed an order dated 4th August 2015 rejecting the present appellant's prayer for mutation in respect of plot P1/221A. This order was challenged by the present appellants before the learned single judge, which resulted in the impugned order being passed. The learned single judge dismissed the writ petition by observing that the estate manager had passed an order which was supported by cogent reasons. The writ court does not act as an appellate authority. Only in exceptional cases where an order is without jurisdiction or passed in breach of the principles of natural justice or there is grave procedural irregularity and the writ court would interfere. We have heard the learned counsel for the parties in this appeal. It appears that on the day the estate manager passed the order which was challenged before the learned single judge in the present proceedings, the appellants were not represented before the estate manager. The estate manager passed the available records of the case and passed the order. The appellants say that the order of vesting was challenged by Sunanda by filing WP 10487W of 2005 by a judgment and order dated 23rd June 2009. A learned single judge of this court set aside the vesting order. The copy of the said order has been handed up. Let the same be kept with the records. The learned advocate appearing for the appellants says that a copy of the said order setting aside the vesting was available with the estate manager. However, There is no reference to such order in the estate manager's order, which is under challenge in these proceedings. We find from the copy of letter dated 22nd July 2009, written by the learned advocate for the appellants to the estate manager Kollani, that a copy of the said order of this court setting aside the vesting in question was received by the estate manager. However, it is possible that when the order of the estate manager came to be passed on 4th August 2015, copy of the said order of this court was not available with him, or the same escaped his notice. The appellants were not presented before the estate manager to point out that there is such a subsisting order. The learned advocate appearing for the state in his usual fairness says that since there is no reference to this order to this court setting aside the vesting in the order of the estate manager, it may be proper to remand the matter back to the estate manager for fresh consideration of the appellant's application for mutation. In view of such fair stand of the state, and since we are
No, my lord, what happened, my lord? My lord, if you also kindly take the third paragraph of that particular judgment. Let a hearing be held to the by the district manager Kollani on May 6, 2022 at 12 noon. But on that very day, the petitioners before your lordship represented by submitting their appearance along with an advocate. But on that very day, the Honorable Division Bench directed the authority concerned to take the decision after giving a hearing on the 6th May, but they did not take any decision. If your lordship then kindly turn the impugned order which is challenged hearing by. Lordship kindly take page 97.
Yes.
In the left hand side, your lordship will find that 13 July 2023. And they passed the impugned order.
This case is take up today pursuant to the order of the Honorable High Court, Calcutta, dated 26th April 2022, directing the estate manager Kollani to take a reasoned decision on the appellant's application in accordance with law. The appellant applications dated 20th January 2012 and 24th September 2012 will duly signed by the Utpal Bhakto and Sushanta Kumar Roy, who are the present petitioners herein, Lordship, are re-examined as per direction of the Honorable High Court, Calcutta, with reference to the documents and papers submitted by them and the office records available with the file. As directed by the Honorable High Court, Calcutta, gone through all the records in respect of plot B1/221A at Kollani. It transpires from the documents that the plot number such and such having the area of 9 kata, 13 chitaks and 27 square feet was bifurcated into two parts. A part of 329.44 square meter, that is 4 kata, 14 chatak and 36 square feet was allowed to retain by the original lessee, Srimati Sunanda Goswami, and the another portion of the comprising an area of 329.43 square meter, that is 4 kata, 14 chatak and 35 square feet was demarcated as B1 221A at Kollani. Now, as per order of the competent authority of SDO Kollani, by such and such dated 7th December 1993, the excess vacant land, which was later demarcated as such and such, was vested in the state of West Bengal, and accordingly, the said plot was resumed and re-entered into the government land.
My lord, they took this same stand, but which was already set aside by the Honorable High Court. My lord, this is the writ petition here. What is it?
The undersigned in also satisfied that a board displaying that the plot has been resumed and re-entered into the government land was also erected after resumption of the said land at the site within the plot B1 to 21A for the information of the general public as per protocol. The transfers that the original lessee Srimati Sunanda Goswami was duly informed by the Urban Land Ceiling Clearance Issuing Authority regarding the action taken by him. In spite of being informed of the said original lessee Srimati Sunanda Goswami sold the piece and parcel of the land comprising with the plot such and such at Kollani Township, the said act of Sunanda Goswami is viewed as arbitrary and illegal. It is also evident that the said lessee had lawfully sold B1 to 21 at Kollani comprising an area of 4 kata, 14 chotak and 36 square feet to one Shanti Ranjan Bakchi, which was duly executed by the office of the undersigned on 20th April 1995 and subsequently registered and duly mutated in favor of the transferee. It also transpired that the said original lessee had taken the due permission from the office of the estate manager Kollani before transferring the said plot of land B1 to 21 in favor of Sri Shanti Ranjan Bakchi, which establishes that the fact that the said lessee Srimati Sunanda Goswami was well aware of the procedure of transfer of the leasehold right under Kollani Township and provision of the terms and condition of the lease deed. Now it transpires from the registered deed dated such and such by the appellant Sri Sushanta Kumar Roy and Sri Utpal Bhakto.
So the authority takes the same stand that vested land has been transferred. Vested land has been transferred. Yes. Who is appeal? Mr. Dey is appeal.
That part is now he is not. Now my lord has come that part. That is second paragraph of 99.
Yes, the authority says that vested land has been transferred.
That is from the registered deed authority that the appellant Sukanta Kumar Rai, Sri Utpal Bhakto, that the said original lessee, Sukanta Goswami has attempted to transfer the government property via of the Kollani estate in It is also evident from the act of the said original lessee that she had attempted the said transfer, knowing fully well to contest contained in the order of the company. ULC and SDO Kollani has known as the commission of the original lease, see the at the said original lessee, Srimati Sunanda Goswami was aware about the provision of the lease deed. She would not have taken the permission from the estate manager. Kollani before transferring plot number 182 its Bakchi in the year 1990. Thus, it is established that the said original lessee, Srimati Sunanda Goswami, had tried to transfer the plot and Utpal Bhakto, disobeying the order of the company. Which Dalabhai which cannot be considered and transfer since the demand said land with the West Bengal of the Kollani. Hence, that is the appellate authority, my lord.
Mr. Dey, this vesting has been set aside.
And against that order of the Honorable Single Judge, no appeal has been preferred by the state as yet.
Where is that order? Setting aside the vesting. Because that's relevant here.
That single bench order was challenged by that is the landed single judge, page 86. This means that in petition by observing that the estate manager had passed an order which was supported by the project does not
Lordship.
act as an appellate authority.
Madam,
In exceptional cases, that is done. We have learned counsel of the parties of appeal, it appears that on the day of the estate manager passed.
my lord, my humble submission,
Before the learned single judge in the present process, the appellants were not represented before the estate manager. The estate manager produced the available records of the case and passed the order. The appellant said that the vesting was challenged by Sunanda. Judgment of order, learned single judge of this court set aside the vesting order. There are, my lord, that two orders is there. One by the learned single judge. That is page 86, my lord.
ওটা ডিভিশন বেঞ্চে এই কথাটা অবজারভেশন আছে।
My lord, 86, learned single judge dismissed the petition and observing that the
Another writ petition.
has passed the order is supported by cogent reasons. And another thing, my lord, second writ petition, my lord, that by judgment and order passed by a single judge, court set aside the vesting order. A copy of the said order has been handed up. Learned advocate appearing by the appellant says that a copy of the said order setting aside the vesting was available with the estate manager. However, there is no reference to the order of the estate manager. We find from the letter dated July written by the single advocate appellant that copy of the said order setting aside the vesting order in question was received by the estate manager. However, it is possible when the order was passed, learned advocate of the state removes that is, my lord, after that, my lord, the estate manager address in view of the affairs and of the auto, the estate manager did not advert to this court's order setting aside the vesting. He set aside the order of the auto manager and estate manager. My lord, I must file an legitimate opposition.
Why don't you come back with a report in the form of an affidavit? With all the
Report will
relevant
also-
documents. Opposition will take very long. You can take this back. Please annex them to your reply.
Lordship, I can come with an Xerox copy. Madam, madam, ওই কাগজটা তো বলি Xerox copy।
Heard learned counsels for the parties. Paragraph learned counsel for the state respondents seeks to submit a report in the form of affidavit in this matter. Paragraph, let the matter appear under the same heading on 16th May.
My lord, only thing, my lord, I am praying an interim order. Till the disposal of this writ petition, no steps, no coercive action shall be entertained. Lordship, kindly consider this aspect.
In appeal or anything else, my lord, there is nothing.
No, no,
of the state
you have not
or-
preferred an appeal. State has not preferred an appeal. When the vesting order has already been set aside.
No, my lord. Sir,
You have hung up a notice which was challenged
The
and the same was allowed by this honorable court. So at least I am entitled to get a minimum protection.
your position is not disturbed. Only your mutation has been turned.
No, Lordship, that's the point is that when they vested, when they passed the order of vesting, before passing the order of vesting, they hang up a notice board.
That
over
is
the-
over. That part is
That is over.
So now you are not
Now-
under threat of disposition.
My lord, at least no further coercive steps, my lord, they can take at any point of time.
If they take, I'll consider. Please come
My lord,
back.
and then my lord,
At the moment, there is no question of taking any coercive steps. Because they have only turned down your mutation.
my lord, at least, my lord, any coercive shall be abide by the result of the writ petition. At least,
my lord.
my lord.
My lord, we
No, it-
pass the order of vesting. After that, there is nothing in the appeal. No stay order is there. After
Yes,
that.
No
order-
stay, you have not
Say that,
stayed.
Mr. De.
Yes, sir.
You have not
No, no,
prepared
no,
appeal.
no, I have not stated so. That we have filed we have passed an order of vesting, my lord. After that, nothing was there.
Yes,
No.
after that, the writ petition
My
was
lord,
there.
that is a setting aside. But in the appeal, there is no any, my lord, injunction or anything else. There is
Appeal
any-
was with regard to a different writ petition altogether.
After that, my lord, order was passed, nothing was there. So, my lord, at this stage, he has not any right to get any
Then-
order.
It is his submission, my lord.
Any
Yes, sir.
steps taken pursuant to this shall abide by the decision, the result of the writ petition.
Grateful to us.
Any step taken by the, date the number. Any step taken by the authority pursuant to the order impugned, passed on 13th July 2023, shall abide by the decision of the writ petition.
Obliged to lordship. আরেকটা কবে দিস?
Mention matters, কবে দিলাম যেটা বলুন।
My lord, I am for
I think
the
the affidavit of
private
service.
respondents 6 to 9.
My lord, I am appearing on behalf of the state, my lord.
My lord, the affidavit of service. My lord, the matter pertains to unauthorized encroachment on Kolkata Bashanti State Highway by putting up a number of shops by the private respondents. Now, my lord, there has been two positive developments pursuant to filing of this writ application. Now, my lord, in the manner, Lordship may kindly take up this communication dated 14th December 2023.
My lord,
A joint inspection, I'm boleni a joint inspection was held and এটা একটু জজ সাহেবকে দিন। A joint inspection was held on 23rd August 2023 by the authorities concerned. Na ওটাও দেখিয়ে দিন। Lordship may kindly take up the second last paragraph. It is worth to mention here that so and so the undersigned requested you by letter dated so and so to arrange one joint inspection of the
this has been
disputed
held.
inspection done, and thereafter, my lord, this is the
Proceeding has been initiated.
proceedings, my lord. This clarifies everything. I think my learned friend for the state has also this copy.
Subdivision, give me instruction, my lord.
On
Encroachment of private.
on 5th January, the notice was served by the state concerned engineer on the private respondents that remove the encroachment within 15 days. Since then, because of pendency of the writ application, they are sitting idle. They are not doing anything. It is a state highway. Kindly seize. They should have, after giving 15 days time, they should have removed the encroachment.
That is that what section 10 says?
My lord, that is what is written in their communication.
Yes, but we have section 10, 2 and 3.
Whether my learned friend has preferred an appeal that he will submit.
Appeal is not necessary at this stage at all, sir.
Then
If section 10(1) is not complied with, we have a section 10 notice and then section 3, 10(3). Yes, has that been done?
Yes, my lord, illegal
This
notice.
is a section 10(1) notice, isn't
Yes,
it?
my lord, yes.
After that, what about 10(2)
No,
and 10(3)?
no improvement for that.
My lord, I'll show some certain facts of his writ petition. My lord will kindly come to page 4 of his writ petition. He has not come up with clean hands.
Yes, page
My lord,
4.
page 4, paragraph 2, he says, the writ petitioner says that he purchased the land on 19th April 2021 on the basis of a registered deed. And then in paragraph 3, he says, the petitioner says that in the end of 2021, the petitioner observed that the private respondents were encroaching the state highway and were making permanent construction shop rooms in the said land. So, my lord, he is saying that we were constructing the shop rooms after 21, at the end of 21. Now, my lord, we'll see this photograph. My lord, these shops existed for last 40 years. The national highway is running there.
Are you claiming adverse possession?
Yes, my lord. Well, we
Filed a suit to
we
the
will file a suit. Whether the title of this person has also been challenged by in a suit that is pending in Baripur.
That is in respect of the private land.
My lord, yes,
It
my
has
lord. Now,
nothing- it has
my lord,
nothing to do with
we will, since this writ petition was pending, I told them. Now, my lord, we'll see this.
Mr. Singh, you'll have an opportunity of hearing before the authority.
My lord,
Please
will
appear
see,
before the
my lord,
authority.
will see that what he is saying. Now, my lord, kindly see this judgment, my lord. Whether this writ petition is maintainable or not.
Yes,
My
relevant
lord,
paragraph.
paragraph 34. And each. My lord, I am taking your lordship to the second page, head note first. It is under paragraph 24.
The jurisdiction of the Supreme Court under Article 32 and of the High Court and Article 226 of the Constitution is extraordinary, equitable, discretionary, prerogative writs mentioned therein are issued for doing substantial justice. It is therefore of utmost necessity, and the petitioner approaching the writ court must come with clean hands, put forward all the facts before the court without concealing or suppressing anything, and seeking an appropriate relief. If there is no candid disclosure of relevant and material facts, or the petitioner is guilty of misleading the court, his petition may be dismissed. My lord, kindly see the next paragraph.
What are the relevant facts which have
My lord,
been
he is saying,
suppressed?
kindly see the writ petition again. He is saying at page 4 again, my lord, paragraph 3. He is saying that we are trying to construct the swap rooms after his purchase in the end of 2021, and his egress and egress has been disturbed. But the swap rooms, behind that, the vacant land is his land, which he is alleged to have purchased. Now, there is, see that photograph, which I handed over to your lordship. There is a Pakka road going to that land.
This court will not go into merits at
My
all.
lord, let the authorities decide. Let the authorities.
Absolutely.
My lord,
You
let
will
the
have an
authorities.
opportunity of hearing
My lord,
from the authorities.
let the authorities decide.
Affidavit of service.
But my lord will kindly record that they have not come with clean hands.
What is the unclean hand?
No, I
The-
fail
the-
to understand
the
how
offer
my
already
learned
there.
senior friend
My-
is justifying
my-
encroachment on state
my-
highway.
My lord, point is that the shops were already there.
I'll record his-
What he stated that we were constructing the shop room.
Absolutely.
These shop rooms existed. He purchased the plot, alleged to have purchased the plot with those shops there already.
If the shop rooms existed prior to his purchase,
Yes.
it's not your own Rayati land. You
No,
verified
no,
upon
that
state
is
highway.
that is altogether different.
Even without an application filed by the petitioner, you
My
have
lord,
to be
my
removed.
lord, the thing is that can be removed by the highway authorities. I'm not standing on that way. But why he is making those allegations which are not correct?
I'll record.
Let my learned senior friend show there's a single wrong allegation in the entire writ application.
I've already shown.
The petitioner claims to be the recorded owner of the plotting question and submits that the private respondents have raised unauthorized construction by encroaching upon PWD road
Well, this is Kolkata Bashanti State Highway.
within bracket Kolkata Bashanti State Highway,
State Highway. State Highway.
adjoining his property, thereby obstructing his egress and ingress. The petitioner submitted a representation before the authority in this regard, pursuant to which the plot in dispute has been demarcated by the Block Land and Land Reforms Officer, Bashanti, South 24 Parganas. And upon detection of unauthorized construction on the said highway, notice under section 10 within bracket 1 of the West Bengal Highways Act 1964 has been issued upon the alleged encroachers. Placing reliance on the report submitted by the assistant engineer, Canning Highway Subdivision, PW within bracket roads department on 8th January 2024, learned counsel for the state respondents submits that notice under section 10 of the Act of 1964 has been issued upon the private respondents directing them to remove the unauthorized construction made by them on state highway within a stipulated time frame. Paragraph. Learned counsel for the private respondents submits that that though the petitioner has alleged that the private respondents have raised the allegedly unauthorized construction sometime in the end of 2021, they have been occupying the shop rooms therein for about
More than 40 years, ma'am.
for more than 40 years. The petitioner, therefore, has not come before this court with clean hands, and the petition ought to be dismissed on that score alone. Stop. Learned Counsel has placed reliance on the decision report on the authority in A.D. Sharma versus Steel Authority of India Limited and others, reported in bracket 2008, 12 Supreme Court cases, 481, in support of his contention. Paragraph. It is right now that the petitioner is guilty of suppression of material and relevant facts or of misleading the court, the writ petition may be dismissed at the threshold without going into merits of the same. Paragraph. In the case in hand, the petitioner purchased the plot in question on 19th April 2021 and found the private respondents to make permanent construction of shop rooms sometime in the end of the same year. Stop. Such factual issue as to the date and period of such construction is a matter of evidence and cannot be dealt with by this court in exercising extraordinary jurisdiction under Article 226 of the Constitution of India. Stop. However, it is not in dispute that the shops run by the private respondents are situated on state highway. Stop. Since notice under Section 10 of the West Bengal Highways Act 1954, 10(1) has by the authority, the concerned authority, being the fourth respondent.
Fourth respondent.
Being the fourth respondent here in is directed to take the proceeding to its logical conclusion within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, in accordance with law. Paragraph, it is made clear that this court has not gone into the merits of the case, and the concerned authority shall be at liberty to deal with the matter independently and without being influenced by any observation which may have been made in this order.
Madam, that will be
Disposed of.
grateful.
Disposed of it, that will appear. Next. Fine.
Lord, I beg to appear on behalf of the petitioner in this matter.
Petition is not maintainable, my lord. If your lordship see prayer A and page, my lord, if you come to page 31, my lord.
If I may, my lord.
Prayer A and page 31.
record of rights.
Yes, my lord.
Not maintainable.
If
You're
I
aware.
may state the crux of the matter in very shortly, my lord.
Not necessary. This court
Lord.
cannot deal with it. I'll grant you
Lord,
liberty.
the
to
difficulty is,
approach
my
the-
lord, the conversion has been made, my lord, by the DLRO, my lord, by the records of the DLRO. Now, my lord, all of a sudden, with this notification, my lord, I am at prejudice, your lordship.
You can
Because, my lord,
approach-
already my building is there.
Please approach the appropriate forum. This court cannot deal with the issue. You're aware. This is Land Reforms Act.
Yes, my lord.
So I'll grant you liberty. Right?
In the event, my lord, no coercive step may be.
Since this court has no jurisdiction, I cannot pass any order at all. You
Very
can
well, my lord.
approach the department.
Very well, my lord.
The matter pertains to the West Bengal Land Reforms Act 1955. Paragraph, the petitioner seeks to withdraw the writ petition and take necessary steps before the appropriate forum for redressal of his grievance. Paragraph, in view of the above, the writ petition being WPA such and such is dismissed for non-prosecution. Liberty is granted to the petitioner to approach the appropriate forum for redressal of his grievance. Paragraph, there shall, however, be no orders to costs as is certified website copy. Next.
Great, my lord.
নাও নামটা দিয়ে দাও পাঠিয়ে দাও
Yes.
I beg to appear for the petition. My lord,
What about the, where is your affidavit?
my lord, the
sir?
prior.
There are several private respondents. Anyone appearing for them?
তুমি বলো তুমি অ্যাপিয়ার করেছো
My lord, I private respondent.
Only 12.
only my lord
My lord,
for starting
So what about the other private respondents? Have you served?
my lord, I have served. Yes,
এটা চ্যালেঞ্জ করেছো না এটা
সব কটা গেছে।
Yes, they are served.
My lord, according to the, my lord, the earlier writ petition, my lord, this is a encroachment by the private respondent over the PWD land. And my lord, a report has been placed, page number 36, my lord. Kindly turn, my lord, this page 36. 36, this is a, my lord, the revenue inspector, my lord, addressing the BLLRO, that may I read, my lord, আপনার নির্দেশ ক্রমে উপরোক্ত কেসগুলো সরজমিনের তদন্তে বাদী বিবাদীগণের উপস্থিতিতে দেখা যায় LR 568 দাগের সংলগ্ন পূর্ব দিকে এবং PWD রোডের পশ্চিম অংশে 4টি দোকানঘর আছে। My lord, 1, 2, 3, 4, all the name are the private respondents, my lord, in this writ petition. And মৌজা ম্যাপ এবং PWD এর অধিগৃহীত ম্যাপ অনুযায়ী দেখা যায় উপরোক্ত 4 জনের 4টি দোকান ঘরই PWD এর অধিগৃহীত জমির মধ্যে অবস্থিত। That is, my lord, the private respondents, my lord, the encroachment has been identified. My lord, I am pressing before your lordship just for execution in the next step, my lord, the proceedings of the section 10, my lord.
দরখাস্ত করেছো অ্যাপ্লিকেশন করেছো অ্যাপ্লিকেশন করেছো রিপ্রেজেন্টেশন রিপ্রেজেন্টেশন কেন
What about this order passed by the district magistrate? What is this order about?
The order
In
It is not
2021?
connected with the present writ petition. First of all, my lord, kindly come to page number 42, where earlier writ petition has been withdrawn by the petitioner on the account of there is certain defects. What
Yes,
is-
so, and liberty was granted.
My lord,
Liberty was granted, but what is the defects? Kindly come to prayer portion, my lord, at page 13. As per their prayer, the encroachment under LR tag number 568,
Page?
in page number 13.
Yes.
LR tag number 568, but in the order, in the report, it said at page, at plot
568.
number 622. It means the
no, my lord, it is
petitioner
completely
claiming owner-
written that LR tag number 568, my lord. Same as per
My
the
lord,
order.
if the prayer and the body of the writ petition is defective, then what is the cure the petitioner made?
My lord, inquiry report already, my lord, established that there is the encroachers.
Forget
And my
about
lord, any kind of technical
If the
defects will
repetition
not the
is
ground for their
defective,
protection.
if the
Already it is inquiry report,
liberty
my lord,
has
it is
given to you-
completely, my lord, this established that they are encroached in the PWD land. And my lord,
There
they
are
just
answer-
for finding some technical defects, which is, my lord, the
My lord,
ground for their protection.
I don't understand what is the technical defect.
technical defect is my
The
lord.
prayer says encroachment is on 568.
My,
568 is petitioner's land. Then how a read
No,
court
my lord,
can
the
pass an
report-
order in read court over a private land?
but my lord, report says, my lord, the
Paragraph 3 of the writ
568.
petition, the encroachment is on
My lord,
LR tag
Encroachment
number.
under ILR tag number 568, where the petitioner claiming the absolute ownership.
No, he is not claiming absolute ownership
My
of
lord.
568.
My
Please
lord.
come to paragraph 3.
Yes, my lord. Under ILR tag number 568.
Unauthorized construction on 568
Yes. Near about
in front of that number 622.
My lord, that means-
under ILR tag number.
Yes.
In front of, it means what, my lord?
So the unauthorized construction is on 568, paragraph 3.
Yes.
The prayer also says unauthorized construction on
The
568.
568 is the land where petitioner is claiming the ownership.
Where
absolute
is
ownership.
that stated?
Kindly बहुत में दिख रहा है उसमें।
How are you affected?
My lord, affected, my lord, this is a in front of,
Where is that stated in your writ petition?
my lord,
In front of your land, where is that stated in,
my lord, I have made this application in
the writ petition?
writ petition, my lord.
You have stated there is
My lord,
unauthorized construction.
page 3, paragraph 3, my lord.
Yes, paragraph 3.
Details of the location upon which the unauthorized construction has been raised and going on permanent construction to Gangasagar to Kochuberia Main Road, Kalibazar, Gangasagar, near about Kalibazar bus stand, under LR Dag number 568 in front of the, my lord, the PWD roads, Dag number 622.
This is not your plot. You have not claimed anything to be your plot. So this is a public interest litigation. How are you affected?
My lord, I am affected, my lord, because this
You
is
have
the
not
front.
stated about your plot number at all. Please show one line that you are the owner of a certain plot and your egress ingress is affected by way of this unauthorized construction. Nothing in the writ petition.
But my lord, it is already detected that. My lord,
detection may
as
be
per,
there.
as per,
It's a public interest litigation.
as per, my lord, this 36 page, my lord.
I have seen that, but this is a public interest litigation in that case.
But my lord,
You are not individually affected. This is a public interest litigation.
but my lord, kindly
You are
give,
on behalf of the public.
no, my lord, kindly my lord, the giving a liberty to file a supplementary affidavit because my lord, my colleague brother, my lord, drafted this, my lord, this writ petition.
Cannot put the blame on your colleague,
Kindly
sir.
appreciate, my lord, because this is my lord difficulties, my lord. If in on
I
part
have
of
the copy of the earlier writ petitions also.
on part of my lord, their my lord defects, my lord, client should not be suffered, my lord. That is my respectful submission. Kindly, my lord, give me a supplementary
If you are
affidavit.
appearing, you should take the responsibility on
My
you,
lord,
sir,
I am.
and not shift it to your junior.
I am known, my lord. No, I am also, my lord, taking the responsibility.
Very
I
well.
am kindly, my lord, giving the liberty.
Affidavit of service. Mr. De for the state.
My lord,
Nothing in the writ petition. Petitioner how can you improve? I don't know.
Kindly, my lord, kindly, my lord, give me a chance
Then,
because,
my
my lord, because, my lord, because, my lord, already, my lord, the competent authority has been detected that they have, my lord,
But you have nothing to do with that.
so, my lord, kindly give me a liberty to my
How-
supplementary affidavit, my lord. Otherwise,
It's by way of
my lord, because this,
your case.
now, because, my lord, this,
You don't even say that the land here, it is adjacent to your land. 568 is in front of PWD roads.
my lord.
So it is not your land. So you are not affected in any manner.
So, my lord, kindly appreciate, my lord, this type of, my lord, incorporation of any, my lord, this way will not change the nature and character of
How
the.
can you incorporate? How will you improve? That is what I'm asking.
Because, my lord, there is a, my lord, illegal construction My lord, that
Forget
is,
about that is there.
that is,
Yes.
that is
How
my,
will you affect it? How will you improve that?
my lord, I will, my lord, in giving me, my lord, the liberty to file, my lord, the supplementary affidavit by which, my lord, this type of, my lord, these facts, my lord, should be incorporated.
The supplementary affidavit?
My lord, just want to see, my lord, my lord, the position, how can I affect it, my lord, by this illegal encroachment?
Let
That
me
is,
come back, let us see.
my lord.
Then, my lord, liberty should be given to file oppositions because
My lord.
with regard to the 568, already a civil suit has or title suit has already been filed by the private respondent number 12 along with other
After
brothers.
filing this writ petition, my lord.
Maybe.
Just for a protection.
And there is a temporary injunction order is there, my lord.
I'll see it on the next date. Let him come back with a
My lord.
supplementary affidavit. Let me see. Affidavit is not required. If it is an order of the court and a plaint,
My-
please show it to me. On the next, the plaint and the order.
The main thing is, my lord, if at all he is claiming there is a disturbance of egress and ingress, then there are hundreds of sub-rooms. The state authority must take action against all the sub-rooms.
Let him come back with the document. Let me see. At present, he has no claim at all.
Right.
Affidavit of service. Paragraph on prayer of the petitioner, liberty is granted to file a supplementary affidavit in this matter. Paragraph, let the matter appear under the same heading on 15th May.
My lord, I.
Next matter.
Seven 36, your lordship, Mr. Owen Banerjee is appearing for this state, my lord. I am seeking 1 day's accommodation, my lord.
No, no, my lord, this is a serious matter. The petition is aged about 90 years.
Yes,
And
what
my
is
lord-
the seriousness about the matter?
Matter, my lord, the valuable property about, my lord, 2.5 bighas have been acquired in 1982. There are several orders, but, my lord, no compensation has been paid till date. And we have given, long ago, my lord, we have given notice the matter would be mentioned and they received the notice.
Acquired in 1982. Your suit, your writ petition is in 2023.
No, earlier or there are orders, several orders, my lord. Kindly see.
So please come back, sir, because the state is not there.
Then, my lord, simple not today, it will remain as it is tomorrow. Not today, they should do.
You want it not today? Very well. Not today.
Because, my lord, I am very much interested. An aged lady of 90 years.
For the petitioner. My lord, the petitioner was living at a housing, my lord,
Who is
a
appearing
flat.
for the respondent?
My lord, I'm appearing.
my lord, the impugned order, my lord, I am filing the supplementary affidavit as your lordship pleased, and also the affidavit of service, my lord. Lord, the fact of the case, my lord, that the father of the petitioner, as back as in 50s, my lord, 1950, he was inducted as a tenant under the respondent. And that building is of 73 years old. And my lord, the area is 450 to 500, my lord, square feet. And there, my lord, after the death of his father, his brothers and his mother went to another place for living. And he, from his childhood, my lord, was living there. And my lord, continuing living. After the death, he prayed on several occasions before the authority to induct him as tenant and to receive the my lord, the rents. But they didn't. And my lord, they kept it pending and they made a hearing giving notice to other brothers. Since the brothers are not interested over the flat, they didn't turn up. So, my lord, the decision was not taken that he will be treated as a tenant. My lord, under the Act 71, my lord, if your lordship kindly see, my lord, page 2, kindly come to, my lord, F, 2F, my lord.
Yes.
Tenant means any person by whom the rent of any premises is or but for a special contract would be payable and includes in the event of such person's death such of his heirs as were ordinarily residing with him at the time of his death. My lord, this has also been, my lord, elaborated in, my lord. If your lordship kindly turn to, my lord, 3, section 3 and subsection B, my lord. A tenant shall be deemed to be ordinarily resident of a government premises if he or any member of his family generally resides in such government premises for not less than 90 days in a period of 4 consecutive months. So, my lord, he is deemed to be a tenant, and my lord, the rent has to be accepted by the authority. My lord, what happened?
There is an undertaking by the
Let me finish.
by the person concerned, my lord, to vacate the
My lord,
premises.
let me finish my case. Why you are interrupting?
Interrupting because
Yes.
after this undertaking, whether anything
My
remains.
lord, by force, that is my allegation. My lord,
After this
my lord, the authority, with the help of the police, they went there. They, my lord, ransacked my house, and my lord, 2 persons, my lord, me and my old wife, were there. We were threatened, and by force, my lord, they take one undertaking.
Have you stated that in
My
the
lord, my lord.
petition? Where is it?
My lord, that has I have submitted, my lord. My lord, let me place my case, and I am showing you, lordship, that I have made the amendment.
Please,
Thereafter,
give me
my
where
lord,
you indicated
my lord.
this.
My lord, paragraph 18, my lord, paragraph 18. Thereafter, the respondent authorities on 21st/12/2023 visited the house of the petitioner with the local police and harassed the petitioner and his wife and threatened them and took an undertaking from the petitioner that he will vacate the property by 5th of January 2024. That is by coercive step. And what is, my lord, since the property is of 73 years, government on several occasions gave an advertisement and also made a press, my lord, conference that they are ready and willing to, my lord, sold out, my lord, the property to the persons who are legally or illegally occupied. So, my lord, I responded that please sell me out. And, my lord, they didn't respond to this. My lord, after this, my lord, filing of this writ application, my lord, they, knowing fully well, the state knowing fully well, my lord, they have given a notice on, my lord, dated 29th February 2024, on 18th of March, which was served upon me, my lord, kindly, that you are to vacate. My lord, I have, my lord, my daughter who was married, who is residing elsewhere. My lord, for my son, I have purchased one flat, my lord, within the radius of 25 kilometers. He is occupying that. And the old lady and me, both are residing there. And they are kindly see, my lord, the press release, where, my lord, in the Vartaman as well as, my lord, in the website, that they are, my lord, want to dispose of the property, my lord, to the persons who are.
Please to the supplementary affidavit.
My lord,
It should come to
my lord.
on record by way of an affidavit.
No, my lord, that one came recently after filing of this writ petition. That's why it is not there. My lord, what I'm praying, my lord, I will file the, my lord, supplementary affidavit. My lord, the authority, my lord, without considering the predicament, that since I am ready and willing to pay the rent, since, my lord, under the regulation, my lord, it has been specifically mentioned, and I am living there from my childhood. After the demise of my father, I am staying there with my wife. And still then, my lord, without accepting rent, they are saying you have not paid rent. Now they have taken a plea that you have purchased a flat somewhere within a radius of 25 kilometers where my son is occupying and living there, a small flat. And my lord, that ground they have taken, and I have annexed, my lord, a list of all the 72 flat owners, where from your lordship will find that, my lord, the landowners who have the flats within a radius of 25 kilometers, they are all allowed to stay there. And those who are not staying, even they were allowed to pay the rent.
Please annex these documents by way of.
Well, Lord, this document is there, my lord, page 45 to, my lord, 45 to 48.
Let us hear what the state has to say.
My lord.
My lord, that is, my lord, what has been accepted, my lord, there he has purchased one flat. My lord, it is the case of the, my lord, petitioner that he wants to, my lord, use these flat, my lord, for his residential purpose, my lord, which is not, my lord, permitted under the law. My lord, I have, my lord, the estate acquisition officer has, my lord, issued proceeding, and thereafter, my lord, they sought for police assistance, and the police, my lord, on police assistance, they went there. When they went there, my lord, they gave an undertaking that, well, we will go to our own flat and will vacate the premises. My lord, that undertaking, my lord, has been given on 5th, and after that, my lord, after giving this undertaking, my lord, this application has been filed to stall, saying that this application undertaking has been taken by force. My lord, this is not at all a fact, my lord. We have gone there. My lord knows for execution, my
Who
lord.
is residing in a flat owned by the petitioner?
My lord, that is page, my lord, 42 onwards. That is, my lord, serial number 5.
Who is residing in, you are occupying that flat?
Yes, I am there. I am there. Me and my wife.
In the purchased flat?
No, my lord, my son and my daughter-in-law.
My lord,
they are occupying, that's a small flat, and that was not purchased. My lord, for the last 5 years that was purchased.
Have you said this in your, disclosed this in your writ petition?
My lord, my lord.
That you have a separate flat?
My lord.
Where is it?
Page 7, my lord, page 7, paragraph 15. This is the rejection order they have quoted, and in that rejection order, my lord, it is stated.
Paragraph 15, my lord, and also in paragraph, my lord, 22.
Is there any rule that if the petitioner has an alternative accommodation, he cannot reside here or purchase this property?
He cannot
because you
reside
have
as a,
separate,
because this is not a, my lord,
My lord, page
this is not a
7,
government
page 51, kindly see, my lord.
retirement, my lord, he can stay, my lord, for an indefinite period. This is not the my lord case.
No, but the Government Premises Tenancy Regulation Act 1976 says otherwise, isn't it? It says
Well,
that anyone who has been residing in that flat with the tenant is entitled to occupy.
My lord, that is
Is
my lord,
there any provision that if the tenant purchases a separate flat of his own, he cannot occupy the government flat? Is there any proviso to this
my lord,
enactment?
they were inducted in as tenant in 1950s.
The father.
So
not
the
yours.
regulation of 1950s will be applicable in my case.
No. When you are applying,
Because if it is not retrospective,
will you come back with the necessary instructions?
my lord, kindly come for a moment, page 51.
that portion, my lord, I will, my lord,
Since learned counsel says that even other tenants who have their own property within 25-kilometer radius have been allowed to purchase or retain. Is there any regulation which says that they will not be allowed to retain?
My lord, let me take specific instruction.
My lord, other residents, my learned friend should clarify also. So far, my lord, the annexures from page 45. My lord, page 45, because if there is any regulation, it should be uniformly applied. Why I will be a scapegoat?
If somebody
Kindly say page 51, my lord, for a moment. Page
No, I
51.
think we have to continue some other day.
Fine.
Heard learned counsel
Let
for
it
the
be
parties.
remain, my lord, I will just take it. sir.
Will you come back with a report?
Yes.
And you want to file a supplementary affidavit
My lord.
with the annexing the documents, all the relevant
My
documents? On prayer of the petitioner, liberty is granted to use a supplementary affidavit, annexing relevant documents. Paragraph learned counsel for the respondents seeks to submit a report in the form of affidavit in this matter. Paragraph let the matter appear under the same heading on 19th April.
Grateful, your lords. My
স্লিপটা দেখি স্লিপটা
Yes, Mr. Mukherjee.
It's a long pending, your lordship, and see. Time and again, I don't know,
Who is appearing for the respondents?
the Ganguly is appearing. Ashim Ganguly is appearing, but since long, this matter is pending, everything has been completed. Time and again, they thought, well, at the adjournment, your lordship, kind of how can one, it's more than near about 1 year is passed. The stage of motion, report filed, the exception served and filed. Small issue involved here. Kindly, your lordship, please, on these things.
I'll record that it will be taken up even in absence of the respondents. Please inform the respondents. I'll record that.
Well, Mr. Devra is there, your lordship, kindly.
Mr. Ganguly is appearing.
Ashim Ganguly.
At several occasions, he is not appearing.
This has never done my learned senior friend, Mr. Devra. Never.
None appears for
I have
the
not got this type of.
none appears for the respondents. No accommodation is sought. Paragraph. Let the matter appear under the same heading on. Why not? I am appearing for this. Led by Mr. Ashim Kumar Gaur. Yes. Had a sleep din na. Dada.
Facts in nutshell. The petitioner made an application for grant of a auto rickshaw permit in route AR3. That way back in 2014. His application was taken up for consideration and the same was rejected on the ground. First, that there for the insufficient financial stability. But that was taken up by the Honorable Court in a writ petition. That is one your lordship will find the order.
This page 21 is the order, I think.
This one, first order is of that is my lordship. Page 21. My lord. Page 21, my lord. So common order, my lord, there the coordinate bench directed to reconsider the application afresh. The page 22, your lordship, in view of the above, the writ petition is disposed of by directing the regional transport region to consider the application of petitioner afresh in accordance with law, giving an opportunity to consult. Remember that at the time of consideration, the petitioner will be entitled to produce his updated bank statement, so to prove his financial stability. Well, that was not given chances. Now, that was taken up for consideration. Very next page, your lordship will find, and the same was taken up for consideration by the authority. That is on 2019, and by an order, by a decision dated, next page. That is of 26th of March 2019. The application was rejected on the grounds in the route there was no vacancy. Last line, your lordship will find page 23. Yes. Challenging that petitioner filed a writ petition. During the pendency of the writ petition, petitioner filed an application under Right to Information Act. That your lordship will find at page 24. There, was found out that a permit which was expired long back, around 10 years back, after filing the writ petition. Now, that report in RTI, subsequently in the writ petition filed, there is supplementary affidavit, leave granted by an coordinate bench. Your lordship will find at page 29. So the petitioner filed a supplementary affidavit annexing the documents that from the RTI report, it is appearing one permit which has already been expired more than 10 years back. So let that be declared a vacant, and applications of the petitioner may be considered in that way. But that writ petition ultimately disposed of by another coordinate bench. Your lordship will find that page. But that is at page 35, annexure P6.
Yes.
There, my lord, the coordinate bench holding that your lordship will find that the statement, well, your lordship kindly come to page 35, last paragraph. No, your lordship kindly come to the last paragraph, page 35, last part, learned counsel appearing for the state's places short sequence of events which would make it clear that the petitioner's first application was rejected on the ground that the petitioner could not prove his financial viability or stability, and the second application, but one second time the application was rejected on the ground no vacancy. The composite affidavit in oppositions filed by the state authorities contains a statement to the effect that a particular permit mentioned in paragraph 13 of the said affidavit, which was not renewed for a long time, subsequently expired. It is admitted that no vacancy is created by reasons of such expiry. Then I placed a judgment passed by another coordinate bench. Your lordship will find that that in the next paragraph, upon considering the submissions of learned counsel appearing for the parties, it appears that a learned single judge, so and so, if a permit is expired, this has declared as outlived, and a vacancy should be declared in that position. So, on that code, this coordinate bench dispose of the writ petition directing to reconsider, declaring a vacancy therein, and the consideration of the application with the other applicants. Now, then, it was taken up for consideration. Now, your lordship kindly come to next page, page 38. Page 38, the decisions arrived at by the respondent in terms of the order passed by the coordinate bench in that matter. Now, there also they decided to reject the application and allowed your lordship will find at page 38 the serial number 7, Abdul Rob Ansari. The earlier,
That is again on financial capability.
he was granted, he was allowed, and my lord, your lordship will find that the RTA found that the applicant Abdul Rob Ansari, the last paragraph, possesses the maximum bank balance in his passbook as on 11/3/2022. RTA selected him following one. Now, that was also challenged. Now, your lordship will find that page 39.
Yes.
That the another coordinate bench held that the rejection is not tenable in the eye of law because of these facts. Your lordship will find that the findings, the other issues were there also, the jurisdiction issues that was also dealt with. Now, your lordship kindly come to the it starts from page, internal page 5, page 43 of my writ petition.
Yes.
Paragraph 16 itself. Again, no explanation has been offered at all in the impugned decisions to take the cut-off date arbitrarily as March 11, 2022 for considering the financial stability of applicants for contract carriage permit. Although the learned single judge in WPA number 20 had passed directions on March 11, 2022 for the RTA Howrah to redecide the matter within a period of 6 weeks from the date by a reasoned order upon hearing all the concerned parties, including the petitioner. It was never stipulated in the said order that the relevant criteria for grant of such permit have to be considered on the yardsticks as applicable on the date of the order itself. In the absence of the impugned order reflecting any reasons for taking the cut-off date, the same has to be struck down as arbitrary. Now, thereafter, my lord, the court set aside the last para 20. My lord, I am not going the paragraph 18 and 19. It is a very important paragraph in the present context. But I am first, my lord, you will also kindly see the page paragraph 20. Hence, although a recent order was passed by the RTA Howrah in terms of order of the learned coordinate bench, the said order has to be set aside on the above grounds. Now, my lord, thereafter, this court directed to consider the applications along with the other applicants. Third, now, my lord, on the basis of in terms of the said order, the petitioner was directed to appear by a notice first dated, my lord, your lordship will find at page 46.
Yes.
By the RTA Kolkata on my lord 7th of September 2022. The first notice to appear for a hearing in terms of that order. Now, my lord, that meeting was deferred to my next page 47. That was deferred and my lord, it was postponed and it was fixed on the next page 20, page 47. That is a date by a notice dated 29th of September 2022. He was asked to appear on 12th of October 2022.
Page 62 is the order impugned.
Now, right one. I will also kindly appreciate one thing. First of all, why I placing the page 47. Now, your lordship will find that the notice, you are also the last line of the notice. You are also requested to bring the following documents in original for verification and one set photocopy of for submission. Now, these are the documents. Now he produced all the documents and hearing took place. So rather an interview took place, my lord, then they arrived at a decision. Now here also your lordship will find the person, I should not say how the person is so blue-eyed, because that person who has got earlier the grantee, he is also here. And only on the grounds your lordship will find that is page 62. It's a communication. From third line, you are present and submitted financial documents with other documents to comply the conditions under section 74 of the Motor Vehicles Act 1988 for grant of permit, since the route is a notified route and the vacancy on this route is one. RTA board verified all the my lord, your lordship kindly take it that RTA board verified all the credentials of all applicants in compliance with section 74 of the Motor Vehicles Act 1988 and found the HON'BLE Rauf Ansari as most credible out of total applicants. Here also, my lord, this Abdul Rauf Ansari, as your lordship has got earlier, he has got because of, according to them, my lord, selected most credible out of total applicants. Now, my lord, I filed a supplementary affidavit.
The report doesn't contain any document on the basis of which
Only
it was
broadsheet.
considered.
As your lordship, I am coming to that. Before that, my lord, I filed, my lord, the supplementary affidavit.
Yes.
As your lordship, that a supplementary affidavit. This is only a communication. That's why, my lord, issue taken, my lord, that supplementary. But where is the resolution? My lord, I have annexed the resolution which I have got later on. So filed this supplementary affidavit, annexing my page 10 of my supplementary affidavit as well also got. As your lordship got it.
Yes.
But there also they have detailed it, hearing took place and this. And there your lordship will find, along with other documents to comply with the so and so, RTA board found that the applicant Abdul Rauf Ansari possessed the maximum bank balance in his passbook. The RTA board selected him following. Number your lordship is directed to file a report by way of a affidavit, annexing my lord, the broadsheet and other things which is required to be considered during the adjudication. Now, my lord, they filed the report, and your lordship will find here they have annexed only, my lord, the resolution which already, my lord, I have annexed in my supplementary affidavit.
Yes.
They have annexed. Thereafter, a page 15 of their report, they annexed a broadsheet in connection with this. Now, your lordship kindly, I filed a exception. Dear my lord, your lordship will find nothing is there. Your lordship, two things has to be considered. My lord, I taking this point that
This is again the same thing on a particular date. The bank balance on a
not
particular
only that,
date.
yes, my lord. Now I
That
my
was
lord,
set
my lord.
aside
Now
on a particular
that
bench.
is the issue, my lord. Now, my lord, in my exception, I have taken the point that two paragraphs of the earlier judgment. That your lordship will find the two paragraphs. What is the paragraph that I have, but that may I, my lord, place, my lord, the two paragraphs, which is what I don't know. My lord, paragraph
Yes,
18,
19.
paragraph 18
Yes.
and 19. My lord, very much, my lord, stability of a person, financial stability.
I think the respondents need to come with the relevant documents.
As your lordship.
From this single document, stability
My lord,
cannot be asserted.
another part, my lord, they in their, my lord, the resolution stated verified all the credentials. My lord, so far, my lord, dictionary meanings of credential is concerned, that your lordship is very much aware. The things they have asked to produce, they are, my lord, the ST, SC, OBC certificate. That should bear some mark while considering an application in a route where the vacancy, quota or vacancies exist. That has to be taken a mark. But if someone has, well, had a credential that he has a certificate of OBC, ST, SC, then that should be given a mark. And well, the other things also there, well, that has to be taken into consideration. Those are the credential to get the mallet. So that has not taken into consideration. That's mallet. That whether mallet.
Yes.
My lord, for this reply, my lord, I require some adjournment because report and the exception is not with me. It is lying with my senior.
Your report doesn't say anything, madam.
My lord,
please come back with the relevant documents.
আপনার হাতেই দিয়েছি আগে।
Please file the relevant documents.
All right, my lord.
All the
Lordship kindly
that the
direct.
resolution has taken care of. The resolution says that the authority has considered all the credentials, all the documents which were placed before the authority. Please file a copy of all those documents.
Lordship so direct, I will file.
Let them come.
Mine. I'm very much protected before my lords,
It is.
because yes,
I've seen
your
that.
lordship has already
seen
passed the
that.
first order.
Thanks.
পরে আপনাকে এখানে নেই। আপনি আপনার নাম্বারটা দিয়ে দিন।
Resolution taken by the RTA board. It's taken third March
তাহলে আরেকটা
2023,
জেরক্স করে দিতে হবে আপনি
turning down the prayer of the demonstrates that
4.25 হচ্ছে 100
all the applicants, including the petitioner, submitted financial documents along with other documents
মেয়ের মিডিলের আগে হবে
before the authority
IND
for consideration of their respective prayers. Stop.
ওই তো 5 তারিখ তারপরে
Besides,
ওরা তো কাজটা
a single document showing bank balance of the applicants on a particular as on a particular date. No other document has found, no other document submitted by the petitioner or the other applicants has found place in the report in the form of affidavit submitted by the respondents. Paragraph. Learned counsel for the respondents. The respondents are directed to submit all relevant documents which were taken into consideration in rejecting the prayer of the petitioner and allowing the prayer of Abdul Rab Ansari, isn't it?
I have submitted.
Abdul Rab Ansari.
Abdul
Rab
Rab
to.
RUB.
RUB.
Abdul Rab Ansari. Paragraph, let the matter appear under the same heading.
My lord, kindly allow such more time because election is, my lord, after May vacation, my lord, that would be convenient because all officers are busy in election.
14th May.
My lord, after
No,
what some more time, my
Not
lord.
necessary.
One week more, my lord.
date today's matter.
My lord,
I've
what?
said 14th May.
Yes, my lord.
It is more
I
than sufficient.
I do agree, my lord, but most of the officers are not available. They are under training. My lord, one week more, my lord. 1 week more, my lord.
Please do not bargain with the court with date. Next matter. I'll pass necessary order on the next day, with or without the report.
As your lordship.
But I am for the private respondent.
Petitioner,
But I am for 789 and 790, similar, same route, same resolution. Can I kindly take up the two matters, matter?
কোন ম্যাটার নেবে?
Anyone.
Seven.
First matter, matter is the first matter. But I have challenged page 70.
is appearing for the state.
But Mr.
In 719,
Sain is appearing for the state, my lord. He is coming, my lord. He told me that he is.
Yes.
he has come already. Arrived.
আপনার রিপোর্টটাই আমি দেখাবো দেখ
Yes.
but page 70 the relevant resolution extract copy of proceeding of the board meeting of the regional transport authority Kolkata region
28/7/2023 at the chamber and such and such. My lord, agenda, ঠিক আছে. Agenda number 15, my lord.
Yes.
12 application for offer letters in the route 219/219/1 and 239 AB. Serial number 1 to 9, the applicants of the route number 219 and 219/1. Serial number 1 to 9. So, my lord, the resolution taken, my lord, second second paragraph. RTA board scrutinize and consider all the applications received in respect to route number 219 in terms of section 71 3D of the Motor Vehicles Act in terms of financial stability, the past experience, past years, income tax returns and current bank balance as on date of application of all the applicants were taken into consideration. In these parameters, Rituparna Dasgupta possessed 1, first position, Ratnanko Saha possessed second position, Biswajit Saha possessed third position, and Sopon Kumar Saha possessed fourth position among the 9 candidates, and selected as successful candidate for receiving offer letter in the route such and such, and the rest 5 applicants were considered and rejected as the vacancy was limited to only 4 in the said route. My lord, I have challenged this resolution by alleging that the selection process is not fair and free and transparent. My lord was pleased to direct my learned friend to file one report. But most surprisingly, my lord, same person filed 2 reports and 2 broadsheet in similar word. Next matter, Mr. Pantu Devra is in the next matter, my lord, other broadsheet, and this matter, other broadsheet. Same persons annexed 2 sets of broadsheets.
Yes, but where are the relevant documents?
Page 11. Page 11 is the broadsheet.
Same resolution.
Same resolution. My lord, kindly see serial number 1, Sopon Kumar Saha, driving license not found as per IT return such and such, marks obtained as per verification, marks obtained, type of bus offered for PS6, experience in years as per verification sheet 6, marks obtained 0.71, total marks obtained 2.52. My lord, got it, madam? My lord, second, third, and fourth. But marks has been given 2.52, 4.77, 4.52, 11.78. My candidate, the petitioner is serial number 6, Purnima Pal.
Yes.
My lord, his marks is her mark is 2.95. But my lord, the experience in years as per verification sheet, it is only written as 3. But my lord, kindly come to my petition, my lord, wherein I have stated that from 1999, my lord, the petitioner is in operation of the transport business, page 66, my lord, once. Page 66.
Yes.
Is a permit part A, and next page, my lord, part B. The permit was issued in the year 1999 and which is valid till now, till 14/7/2024. As such, my lord, the experience of the petitioner for 23 years. But they have recorded as experience as 3 years, but as per broadsheet, my lord. Yeah, after report. Marks and my lord, in my exception, my lord, I have stated in paragraph 3, my lord, in 2 matters, I used 1 exception. My lord, paragraph 3, from the said synopsis of documents, it is found
the total marks obtained by the applicants include marks obtained on the basis of educational qualification. In this matter, my learned senior friend, Mr. Sen, senior Sen, excluded educational qualification as not tenable. My lord, so my lord, I am coming to paragraph number 4. And my lord, in page 3, the serial number.
It's not been considered in this.
Yes,
draft.
in this matter they did not consider, but next matter, my lord, they consider. My lord, page 3, the rank is Sopon Kumar Saha 2.52, Biswajit Saha 4.77, Ratnanko Saha 4.52, Rituparna Dasgupta 11.78, Sudeep Kundu 3.17. It is much higher than serial number 1. And my client Purnima Pal 2.95. With the experience of 3 years. If it is calculated as the experience of 23 years, my mark would be more higher than other candidates. I have stated in my exception also. Paragraph 4, that from the said synopsis of document, it is found that all the 4 selected candidates offered to place BS6 CNG Eurobus for obtaining permit on the said route. But most unfortunately, the first selected candidate offered vehicle number such and such, registration number, registration date 15/11/2017, not BS6 model. Second selected candidate offered vehicle number such and such, registration date 2014. Third selected candidate offered vehicle number, registration date 2012. And fourth registration date 2016. And all the vehicles are not a BS6 model vehicle, and all are BS4 model vehicle. But I have stated, and the Regional Transport Authority, Kolkata region, issued permits to them against those vehicles which are not at all BS6 CNG buses, but all are BS4 norms vehicle, and the RTA Kolkata region most illegally and willfully issued such permits by showing favoritism to them without following the government order, where new permits could be issued in the KMA area only with buses with BS6 norms and such and such. Paragraph 5, that I further state that I submitted, my lord, annexed R2, my lord, I have annexed the documents of the vehicles of all the selected candidates from where it is established the vehicle is of 2012 model, 2014 model, 2016 model, and 27 models. My lord, paragraph 5, my lord, I have stated that I submitted my several permits for showing my experience in the transport business at the time of hearing, out of which I have submitted copy of my first permit on route number 202, which was issued in the year 1999 and which is still valid up to 14th July 2024 after renewal for several times by the authority. As such, I am in the transport business for the last 24 years and my experience might be considered for 24 years. But most unfortunately, the authority indicated my experience for 3 years only, which is completely wrong. But I have annexed copies of all my permits in the instant writ petition. Therefore, there is wrong calculation of experience in my case, and if such experience for 24 years was calculated, I could get higher marks than others, and I would be eligible for granting offer letter permit on the route. As such, the said resolution dated 27 September 2023 is liable to be cancelled. Well, my submission is that the selection process is completely bad in law, not transparent, fair, and authority favored the 4 candidates by discriminating with others. And my lord,
Where is the notification showing that only BS6 vehicles will be allowed?
my lord, in the broadsheet, my lord, kindly come to page 11 of the broadsheet submitted by Mr. Sen, my lord. Serial number, type of bus offered for H, table H. Type of bus offered for Sopon Kumar Saha BS6, Biswajit Saha CNG, Ratnanko Saha Eurobus, Rituparna Dasgupta BS6. It has been clearly stated, my lord, in the broadsheet.
So you say that they have actually not placed BS6 vehicles?
Not, my lord, not at all.
That is
and my lord, the marks obtained by them is much lower than the petitioner. Well, it is their document, the document of the authority.
Yes, let Mr. Sen.
Whatever the my lord, the papers submitted by the my lord, the applicants who were on the fray. On the basis of this, my lord, this assessment was made. Now, if somebody says after that no, something has to be gone in my credit because of the fact that with regard to experience or other thing, whatever in your record that is not correct. But on the basis of the record, whatever my lord, the candidates submitted, my lord, in support of their claim with regard to the experience and other thing, that what type of vehicle they wanted to place, everything that is my lord, reflected here.
Have you verified if the same vehicle was placed? What was offered to be placed and the vehicle actually placed?
My lord, that
Is
is
there any verification to that effect?
that is not in my report. Report does not reflect
That has to be verified by the authority, because the allegation is that they have offered to place BS6 vehicles. They have not done so.
That, my lord, that is not in the report.
That is one of the issues.
That is not.
The other issue is educational qualification in the second matter, which cannot be taken into consideration. It has
Now, my
been
lord,
taken.
now, my lord, in my report, if your lordship, my lord, at paragraph number, if your lordship kindly come to paragraph number 5 at page 5. That had it been the fact that said educational qualification of the candidates were not considered, then what would have been the picture with regard to that, my lord, after the assessment was done? What would have been the picture? The deponent, however, submits that had the educational qualification of those 9 candidates who were on the fray not been considered for the purpose of taking decision as to the comparable maximum suitability of the said candidates, then the comparative chart of those candidates for the purpose of said consideration would have been as depicted in a separate sheet, being annexure R5. My lord, kindly come to R5. Everything is there except the educational qualification which was considered. Fact. Now, had it not been considered, then what would have been the position of all the 9 candidates? Lordship, kindly come to this, my lord. Then the position of Purnima Pal still would be, Lordship, 6th position. 6th position.
No. Sorry.
Now, Lordship, kindly come. Here there is
document, it is not considered.
Here there is no such column regarding educational qualifications. Now, the number which was awarded, my lord, that is the middle portion of annual income, whatever they have submitted, and there is no such issue with regard to annual income. And on the basis of this, my lord, the maximum marks 15 and then divided by 9. Everybody has been, then my lord, present balance, there are also marks given as per verification sheet. Then types of bus offered. Here, my lord, the issue raised that the type of bus offered, my lord, serial number 1, 2, 3, 4, who happen to be succeeded candidates, they offered BS6 CNJ Eurobus BS6, and their corresponding marks. It appears that when BS6, then candidate number 2, the selected candidate 2, he got 6. And
This is not for BS6. This is for experience.
Sorry.
Number.
Number. No number. Sorry. Then my lord, previous experience. Then number given on the basis of experience. And the total marks in this way, right hand side.
This is also wrong, the previous experience.
According to him. According to him.
Even according to the documents.
No. According to this chart, his experience which is shown against serial number 6 as per verification sheet 3.
What is the basis?
কোনো guideline?
এখানটা একবার একটু বলে দিই টোটাল মার্কসটাও বেশি
Now, on the basis of that,
মার্কস
total marks, my lord, that is the, my lord, the calculation of the individual and independent marks, then the total marks given. And on that basis, it appears that out of 4 vacancy, my lord, he stood 6.
higher than serial number 1.
And then 2.95.
Two things, Mr. Sen. One is the experience part, and another is whether the private respondents have actually placed BS6 vehicles as per rule. These 2 points need to be clarified,
I have,
isn't it?
my lord, regarding,
But this is only a synopsis.
this is synopsis.
So this should be supported by the relevant documents.
Well, regarding placement of the vehicle, I can satisfy your lordship here and now.
But on the basis of placement of vehicles, my lord, no point was awarded.
No,
That
but
is the subsequent to this.
vehicles have to be placed. That's
May I tell one thing? May I tell one thing? My lord, the placement of vehicle is the, my lord, the subsequent, my lord, the cause of action or whatever it may be. We can challenge the same on the basis of that. That does not mean that the, my lord, the initial decision was wrong.
the experience
Because
part is
the,
also not
yes,
right.
that may be, but the, suppose somebody, my lord, the committed that he would place BS6 vehicle. But after obtaining offer letter, if he did not, my lord, place the same, then that is, my lord, maybe a cause challenging his particular that permit. But
So in
not
that
that the decision taken, so she kindly
No,
consider
the offer letter has to be cancelled and the next candidate has to be given preference in that case.
that individual offer letter and or permit, that may be challenged. I am not on that. May I tell? But so far the decision is concerned, whether that commitment might have influenced decision, had it been that on the basis of that commitment, any marks was awarded. That is not. BS4 or BS3 or whatever be the model of pass that would have been placed as per the commitment, but that did not influence the decision-making process, what I am telling before your lordship. The decision-making process has not been influenced. The decision was taken on the basis of other some factors. That might have been that the experience and other thing. The financial stability also. Now the financial stability, my lord, there is no such issue with regard to the financial stability. The only thing is that the experience.
Yes.
Now, experience, yes. If he says that experience should have been much more point, would have been awarded, then, my lord, my humble submission that on the basis of, my lord, the whatever he placed his document, on the basis of this, it has been awarded. Now, and so far that, my lord, his failure to, my lord, to keep his commitment with regard to that BS6 or BS, whatever be the module of the buses, I mean, that failure, he can challenge that particular permit. That somebody obtained the permit.
He's challenging all the 4 permits. He says all the 4 are there, none of them are BS6 compliant.
No, he has not challenged the permit.
My lord, I have
Permit,
annexed the documents. I have annexed the documents of the vehicles of the 4 applicants.
Yes, yes.
এই যে লাফিয়ে ওঠা না, এটার অর্থ হচ্ছে তোমার কোনো প্রবলেম আছে।
সে তো আছেই।
না, কিন্তু কেন? তুমি কি মনে হচ্ছে চুপচাপ তোমাকে শুনবে?
How do you clarify the experience part?
I'm coming. Now, first of all, lordship, that challenging permit is the consequential matter. whether what he has challenged the decision. Now the decision making process whether was influenced by any commitment or not. When decision making process was not influenced by any such commitment, that if any offer letter is issued in my favor, I would place this type of vehicle, and that, my lord, has not influenced the decision making process. No marks awarded, BS4 or BS6, whatever you give, but the decision was taken on the basis of other parameters, experience and the financial stability. Now, financial stability is not an issue here. Now he said, so apart from whatever the model of the past they placed after obtaining the permit or offer letter, and my lord, the suitability of the, my lord, their candidature with regard to their financial stability. Apart from that, only thing now he says that his experience, the marks which have been awarded would have been much more. And if that was awarded, then his place should be, my lord, at least the second or third position, I do not know, but within that 4, because vacancy 4.
Yes.
Then, my lord, we should, my lord, pinpoint, or kindly consider my humble submission, that if that marks would have been awarded in his favor with regard to that experience, then what would have been his position? Naturally, my lord, cannot be that 4 permits should go. That is not. What I tell before your lordship is that this is one type of elimination process, lordship. Kindly consider.
Yes.
His prayer may be something else, but the elimination process, if we go through actual what he prays, actual his prayer is that if this experience is given credit to his account, then his position would have been much better. Much better comparison to whom? Let us, my lord, concentrate on this. At a stage, at one go, instead of 4 permits should go, my humble submission. Let him say that if that marks would have been awarded, what would have been his position? First position, then that somebody should go. He should now say that after whether his position should have been 2, should have been 3, then this table should have been disturbed. I'm not on that. Table should be disturbed. But that does not mean that 4 permits should go at one stroke, because he has not been awarded the permit. Well, my humble submission is this, that first of all, whether the decision-making process was vitiated or not. If vitiated, lordship, kindly consider, if vitiated, then to what extent? But there are certain parameters. To what extent? Whether all 4 permits should go.
So let us take the experience part first.
If the experience is taken, which according to him has not been taken, as per, my lord, his claim.
It looks that it has not been taken.
Very good, my lord. Then what would have been his position? Because if he comes to, my lord, within that 4, then one should go. There is no doubt about it. Then subject to, my lord, after hearing them.
His permit was issued in 1999.
Now it appears, but I do not know whether at the time of that consideration, what paper he submitted, or kindly consider. Everything depends on the papers the candidates who were on the fray, they have submitted. Because nothing is even on the petition. On the petition, my lord, the averments mostly that it was not done fairly and it has been done illegally, according to petition. Nothing disclosed on that. Now he says that no, my experience would have been much more, because now I leave it to your lordship. Either my lord can say that very good on the basis of
Come to R5 of your report.
And my lord, another thing is this experience, my lord, I have to take also, my lord, instruction that experience part, experience in years as per verification sheet, my lord, serial number 1, against that it is mentioned 6, serial number 220, serial number 320, then 18, then 11, 3. Whether it qualifies years or not.
It is stated at the top, experience in years.
Previous experience of running bus, experience in year, then there is year.
So for 20 years, you have granted 2.38 marks.
Previous
For 20 years experience. Right?
Yes.
Serial number 2 and 3. His experience appears to be at least 24 years. So even if you grant him this 20 years marks, which is 2.38,
yes,
his position rises within, he'll be third, I think, in that case. If not second.
Second.
He'll be second, right?
Yes.
His permit was issued in 1999.
That's it, then one has to. Because vacancy is 4. Vacancy is 4.
This is with regard to the field. Subsequently, at the time of placing of vehicles, if it is found that the vehicles were not BS6 compliant, offer letters could not have been issued or should have been cancelled. That is consequential because they have offered to place BS6 vehicles. If at the time of placement, they do not place BS6 vehicles, permits cannot be issued. So these are the 2 points that has to be taken into consideration.
No, but one thing, my lord, I think.
Even if that is not taken,
No,
the second point.
Yes, I am not on that because that was not the, my lord, any parameters with regard to consideration.
Not with regard to consideration, but it is consequential. You cannot ignore that point. Vehicles have to be placed in terms of the.
My lord, just my lord, my duty is to assist the court, my lord. My lord, so far my knowledge goes, my lord, may I tell. Suppose, my lord, somebody says that yes, I want to place BS6 vehicles. That has been recorded there. But later on, suppose I am not on the side of anybody, my lord. I just on the behalf of on behalf of the authority. Later, if it is found that no, though commitment was there, or somebody undertook that you place a higher model vehicle or latest model BS6 vehicle, but actually after offer letter, he did not place the BS6, but suppose BS4 vehicle. Now the question is, my lord, naturally would have come that when that was not a part of consideration, then whether he should be compelled to do that unless the law says that yes, you have to place BS6 vehicles. Because law not yet says that.
Breach of contract.
No, breach of contract, my lord, may I tell before your lordship that that the contract, the breach of contract, because if the other party.
Offer letter is kind of a contract between the party and the authority. You are issuing offer letter on certain terms and conditions.
No, whether in the offer letter itself BS6 was there or not.
Has to be because here it says BS6.
No, there was not. There was not.
So will you
It
come
was type of bus they offered for at the time of consideration.
Commitment.
Yes. But that if that did not reflect in the offer letter or in the decision-making process, then my humble submission, I leave it to your lordship to consider this argument, that would do nothing with regard to the, my lord, the cancellation of the permit, because I say before.
In that case, we have to see the offer.
Because yes, offer letter, yes. Now, because the offer now is second stage, it starts from offer letter. If it appears in the offer letter itself that this permit will be given to you subject to placement of this vehicle, subject to these terms, then one has to comply that term. No doubt about it. And in that case, that breach of terms or breach of offer letter. Because I offer it, you have to accept it on its total.
Yes.
Yes, offer letter is not here. Offer letter, if you lordship say, I can place the offer
That
letter.
is secondary.
Second,
But primarily, it appears that there has been a mistake.
has been
A mistake on the part of the authority.
with
With regard to this experience. part.
experience part. Experience part. That has to be considered.
If you want to take further instruction, you can. I'll hear Mr. Chatterjee in the meantime.
One moment, man.
Then, my lord, kindly, my lord, mention the same
I
so
will-
that
I will.
I can interact with them on that
I
specific
will.
point.
My only point, my lord, page 6
Of the writ-
of my writ petition. Page 6, point number 20. X6. Permit copy A plus B part 20, root number 202. Permit
point
copy
number
10 and 20, man. XX. Permit copy A plus B part, A plus B part, root number 202, which I have shown earlier, my lord. Permit copy of root number 202, page 6 of my writ petition. And which I have annexed in my writ petition, my lord, also. My lord, furthermore, my lord, if the total marks, my lord, please consider the total marks. 2.52, serial number 1. Second, 4.77. Third, 4.52. Fourth, 11.78. Next, 3.17, higher than serial number 1.
So if two is having
Next matter, my lord, 3.17. It goes, my lord, it would be higher than the first candidate. 3.17. And my lord,
not more than the first candidate.
yes, 2.52, serial number 1.
First candidate is 11.78.
No, my lord, serial number 1. I am showing serial number 1. Page
Serial
11.
number 1 is not has not qualified.
Yes, qualified. 1, 2, 3, 4.
May I tell, my lord,
1, 2, 3, 4
this chart,
is qualified.
this chart before your lordship is that, if your lordship kindly have a look, paragraph number 5, that in case of this chart is, this chart, by this chart, we want to depict the picture what would have been if the educational qualification had not been considered. That marks awarded against educational qualification, if the same are, my lord, deleted, then what would have been the position? Because this is not the actual chart. That naturally, in terms of
Even
paragraph 5,
in that case,
they
I
even
find
then
that Shudip Kundu is higher. Why haven't you taken him?
Yes, and Purnima Pal, the petitioner herein,
this
higher
chart,
than serial number 1.
this chart is not the, my lord, actual chart, because in the actual data, educational qualification was considered.
So that cannot be considered. Let us.
And on the basis of that, my lord, the offer letters issued. And so far this chart is concerned, it is shown before your lordship that even if the educational qualification ought not to have considered or had not been considered, suppose,
Oh, you have
then
issued-
what would have been the position? Even then, the present petitioner's position would be serial number 6. That means that out of 4 vacancies, that means he has nothing to say. He has no locus standi.
And
Kindly-
offer letters were issued upon consideration of
Educational qualification also.
No,
Educational qualification to consider করেইছে না নাকি?
But in this broadsheet, education qualification is not included.
Yes,
Serial number
I
not
agree.
included, but offer letters have been issued in terms of that, isn't it?
in terms of educational
considered-
qualifications.
Yes,
Yes.
That
that point was
No, 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 no,
matter.
no, not at all.
My lord,
Not at all.
matter. I
But
thought it was this
No, no, not at all. Offer letter was issued considering the total marks obtained.
Total
Now,
marks of
now, if your lordship deleted the educational marks, even then only this person,
offer
Swapan Kumar Saha is doubtful.
when offer letter was issued,
Only Swapan Kumar Saha is doubtful. Not anybody else.
And I also find that one person, Shruti Pukundu, has got higher marks.
He has not offered any vehicle. If there is no vehicle, no question of granting any permit.
He is not the petitioner, so let us not consider.
He next matter, he is the petitioner. Maybe, but he has not offered any vehicle.
But my lord, if the offer letter is issued, my lord, then
Look, that is separate issue.
In my report, whatever the affidavit, subparagraph 5, Roman 5 at page 4, it is stated therein on affidavit, my lord, affidavit filed by STS Secretary, that RTA board scrutinized and considered at page 4 of the affidavit.
Yes, yes.
RTA board scrutinized and considered all 9 applicants, including the petitioner's application received in respect of route number such and such, in terms of section 71(3)(d) of the Motor Vehicle Act 88. In course of such consideration, the educational qualifications, financial stability, the previous year's income tax return and current bank balance of all the applicants were taken into consideration. And in these parameters, Purnima Pal, the petitioner, possessed 7th position among the 9 applicants. Now the depiction that is at, my lord, the annexed R5, that if the said educational qualification had not been considered, then what would have been the position? So RTA secretary said that yes, we consider educational qualification.
But even without that, one thing is offer letters have been issued considering the educational qualification, which ought not to have been done. There is no rule. Secondly,
The decision-making process, yes, it was taken.
This experience part, it's prima facie, it appears that it has been wrongly assessed. For 20 years of experience, 2.38 has been granted. So the petitioner's experience is 24 years, if not more. So if you add 2 to this, petitioner gets 4.95.
So that one, whatever on record, my lord, I have nothing.
So 4.95 is second.
second. Well, this is the document placed by the authority.
And so Ratnanko Shah has to
Authority has to
go out.
take a fair stand that yes, this would have been the position. Because initial decision was taken as per RTA secretary affidavit. Some credit went to everybody's pocket with regard to the, my lord, the education qualification point. If that is withdrawn, that education qualification point, then the position stand in this.
Still, this part has to be reconsidered.
But I leave it to your lordship.
Now, as Mr. Samanto has indicated, the 2 years experience, 20 years experience, 24 experience, and as per the chart, experience in years as per verification sheet. Here the experience is indicated 3. It ought to have been 24 according to your lordship. Even if I accept that it is 24, then this position, your lordship kindly appreciate one thing, that this chart does not reflect the educational qualification. Even if the educational qualification is taken into consideration, the 24 years is come into consideration, then Purnima Pal could have been come in number 1 or number 2 position. Could have been come for argument's sake. And regarding Swapon Kumar Saha, his position, if the experience column is taken, then as it is stands today, he is doubtful. Now your lordship has to consider what are the records, what are the documents, what are the things have been submitted before the authority at the time of consideration of the application. That record will reflect, will reveal what is that, what is there actually. Because Mr. Samanto has said that permit, he has given 2 permits. No experience column has been given in the 2 permits. Only route number 202, part A and part B, route number 202, part A and part B.
The issuance of the permit reflects experience.
It may be he has 6 permits in route number 202 because there is no bar. I have done certain matters in route number 202, one person having 4, 5, 6 permits.
So the longest permit will be taken into consideration?
No. My lord, if your lordship can appreciate. Now, my lord, if I have the permit of 24 years experience if I do not place that permit. If I place any permit of 4 years experience, that is relatively new, BS4 or BS6 vehicle, I could have think that if I place this experience column certificate, then it could have been gone easily because old permit may not be considered. It may be because no, unless your lordship sees the record and the parameters taken by the authority, what are the parameters taken by the authority? Unless that is confirmed, privacy your lordship may, but confirmed opinion finally it cannot go.
I will call for the record.
Yes, number one. Number two, Mr. Samanto has said that he has, my clients, all 4 clients have offered BS4, CNG, Eurobus, BS4. Number
BS6.
BS6. Number offer is one thing. On the basis of that offer, whether the authority is swayed and granting marks or not, whether selection process has been vitiated by this offer or not, it's not. In the selection process, there is no reflection of the what type of vehicle, which mark maker will be given. Now, into 2023, I have in my affidavit in opposition, I have enclosed. In opposition, because Mr. Samanto has said, your lordship can see his specific language, his exception. His exception, your lordship can see first. Yes. Your lordship kindly come to paragraph 4, paragraph 4.
Yes.
Paragraph 4. That from the said synopsis of documents, it is found that all 4 selected candidates offered to place BS6 CNG Eurobus for obtaining permit on the said route, but most unfortunately, first selected candidate offered the vehicle of 2017, second 2014, third 2012, fourth 2016, and the Regional Transport Authority Kolkata region issued permit to them against those vehicles which are not at all BS6 CNG buses but are all BS4 norms vehicles, and the RTA Kolkata region most illegally and willfully issued said permit by showing favoritism to them without following the government order, where new permits could be issued in KM area only with buses BS6 norms. BS6 norms. This is a specific submission. Now, your lordship kindly come to my affidavit in opposition.
Yes.
Now, in affidavit in opposition, this is affirmed by Shopon Kumar Saha. Offer letter is at page 7. In the offer letter, the authority has said that I have to submit the vehicles conforming the eligible norms. Last serial N, your lordship kindly see. I have to submit the vehicle. Eligible emission norms of CNG battery operated vehicle equivalent to category must be complied.
What is this equivalent category?
Now, what is the equivalent? Equivalent by notification made by the authority as on that date or prior to that date, that which is relevant on at that point of time.
Not the government order.
Government order? What is?
By the petitioner.
There no number, nothing has been given. Now, your lordship kindly come to the next page. This is the government order of the Transport Department, 2nd June 2023. Now, your lordship kindly come to page 9.
This doesn't deal with issuance of permit.
No. Restriction of allied services. No new permit shall be issued. Your lordship kindly see. Page 8. Clause II, clause A, then 1. English 1.
Yes.
No new permit shall be issued by any authority having originating terminating point at CBD Kolkata, Esplanade, Bandstand, Kolkata, Howrah Station, Rabindra Setu approach, passing, etc., etc. In case of interstate route, the State Transport Authority will encourage placement of BS4 emission norms compliant vehicle preferably. The State Transport Authority of all reciprocating states may be informed may be informed, requested the State Transport Authority West Bengal to issue their permits reciprocity accordingly. In case of interregional routes having originating and terminating point in Kolkata metropolitan area, the vehicle to be placed in the permit may be preferable BS4 emission norms compliant, not BS6.
Even in 4 is applicable in your case.
Yes, I have given 4. I have given 4. There is no dispute about it.
This point is not really
Very important. Only issue which is stuck to my mind, I must very clear to your lordship regarding experience. Yes, 24 years, 3. And in my case, what is their number of years of experience in the operation? I do not know. I have not taken any instruction from my learned junior. But even then, they have given your lordship. Can you see?
record is at 20.
No.
In the first was
Your lordship kindly come to.
Kindly come
না,
to point.
আরে ভাই আছে ওটা আমি জানি, আমি দেখাচ্ছি, আমার শেষ করিনি এখনো। জজ সাহেব তো আমায় জিজ্ঞেস করছেন, এত লাফাচ্ছ কেন?
not less than BS4.
Not less than BS4.
Next, may preferably by BS6.
Not less than BS4. In 4. Point number 4. So BS4 is fine.
Yes.
Yes. Now your
Doesn't help you.
now your lordship kindly come to the chart of Mr. Sen's exception.
Yes.
In Mr. Sen's exception, the chart indicates that number 2, Vishwajit Saha 20 experience, then Ratnanku Saha 20, then Rituparna Dasgupta 18. Under any circumstances, these 3 persons' position cannot be disturbed.
Yes.
So, my lord, if this person, Purnima Pal 6, comes into fray, then number 1 may go. Then record placed by number 1, why he has given 6 and why she has given 3. It has to be checked.
Let these 2 records come.
Yes, this has to be checked. Unless this is checked, court is confirmed to that extent. Then the question of.
In fact, I was always on this. That
Yes,
somebody
yes.
that has to be that one. Let us that find out that who is that person.
So, my lord, it's not unknown to me because during the conference I have expressed my opinion to the clients that this is the thing. If the records come, then at the outset I shall indicate, my lord, that the educational qualification should go. What will be the position the educational qualification? We have to go into that. Educational position cannot be taken at least till your lordship's judgment is there. If it is disturbed by appeal court or any other thing, then thing could have been different. Till it is there, I cannot say I will make different submission on that.
So let the records come before.
Now, only that in respect of these 2 persons, 6 and number 1 and number 6, the records is required. And in respect of Sudeep Kundu, he has not placed any vehicle. This is clear from the chart.
Kundu.
Serial number 5.
Serial number 5 has not been granted offer.
No, not granted. He cannot.
Based only upon grant of offer letter.
No, my lord. Most likely, Mr. Debra is aware of that. That decision is not with me. I have moved one application before Honorable Justice Satyabodha Sinha when his lordship was taking this determination. I was also expressing the opinion as opined by this honorable court. When the offer letter will issue, then I shall place the vehicle. Then my lord Justice Sinha was pleased to opine that what the authority will consider from the year that after issuing offer letter, he will place the vehicle and they will leave a person who has already offered a vehicle.
But please see the language of the offer letter. It asks you to place.
Yes, that's right.
It
Because
doesn't say that it is already
because the authority has considered my suitability. That's why authority asked me. I have indicated.
But that issue, my lord, at least 25 years back.
Yes.
My lord, Justice Dipankar Datta then also appeared for my lord somebody. I appeared for somebody, petitioners. All of us then appeared for petitioners. No, a question came up before Justice S.B. Sinha. My lord, at least 5 or 6 my lord, were there. Our my lord, 5-6 petitions my lord, were taken up jointly. And my lord, it failed from lordship that you applied without any vehicle. And your application will be considered.
Therefore, rule has been.
Hal nei, torwal nei, nidhinam shabda.
Yes.
This is my heart actually said.
But unfortunately, that
Thereafter, if provision- No, thereafter, no. Rule was there. Then, my lord, we jointly prayed before your lordship that consider the rule 141, where that rule is specifically for that if somebody applies without any vehicle, without saying that, yes, I shall, but the undertaking should be there in that, and the form also there, that is that I shall place the vehicle if offer letter is granted in my favor. And the rule 141 also the same language.
Yes.
Because, my lord, suppose, my lord, the no offer letter granted, application rejected.
That has also not been done here. Otherwise, if he could have said that I shall place BS6, he could have. Here, your lordship can see Purnima Pal has indicated BS6.
Yes.
She has offered BS6. Whether after obtaining offer letter, what vehicle he could have placed, I do not know, but she has offered. But in case of Sudip Kundu, he has not offered any vehicle. He has not offered any vehicle.
সিরিয়াল নাম্বার এতে উঠে যাচ্ছে, এক নম্বর চলে যাচ্ছে।
Let me pass an order in this matter. Let the documents come. The experience related documents.
Experience, only experience.
Order filter.
তাই তো? হ্যাঁ, তুই তো সেই কথাই বলেছিস। আমার লোকজন তো
resolution
789
জজসাহেব তো উঠে যাবে। হ্যাঁ, 3:30 তো ভুলেই গেছি।
taken by the RTA board in its meeting held on 28th July 2023.
এই আস্তে আস্তে শুনতে দাও অর্ডার।
So far as in respect of route numbers 219 and 219/1 is assumed in the writ petition. The petitioner herein is agreed by the resolution on twofold grounds. Colon dash.
বলুন সামন্ত, এটা ভাস্কর প্রথম কোথায় শুনতে এত আলাভোলা হয়।
Experience experience of running a bus. Previous experience of running a bus and experience in years by years as per verification sheet. The petitioner's experience has been held to be 3 years by the authority, whereas 3 years by the authority and marks allotted to the petitioner in this regard is 0.36. Stop. Permit was issued in favor of the petitioner sometime in 1999, which is valid till date. So therefore, the experience of the petitioner in running a bus is at least 24 years. Stop.
না পিটিশনার তুমি তোমার নম্বর
Advocates Vishwajit Saha and Ratnanko Saha, whose experiences have been recorded as 20 years, have been granted marks, have been allotted 2.38 marks. The petitioner's experience is counted as 24 years, comma, the total marks of the petitioner shall definitely increase, and the petitioner shall come into the zone of consideration of the authority in terms of vacancies, in terms of 4 vacancies. Secondly, comma, secondly, comma, so the private respondent offered to place A6/CNG vehicles/Eurobus at the time of submitting their respective applications, comma. They have placed these 4 vehicles upon issuance of offer letter in their favor. Paragraph. It appears from the copy of an offer letter submitted on behalf of the private respondents, annexed on behalf of the private respondents, in the affidavit in opposition filed by them, that the offer letter does not indicate, does not specify that the applicants ought to place PS6 compliant vehicles. The notification issued by the Transport Department, Government of West Bengal on 2nd June 2023 demonstrates that the route is exclusively within the Kolkata metropolitan area, comma, new permit being issued by the STA or by any RTA if the by any RTA, the vehicle to be placed in permit, comma, may preferably be BS6 emissions norms compliant, but not less than BS4 norms compliant. Stop, inverted comma, closed. The case in hand, comma. Since the private respondents have placed BS4 compliant vehicles, comma, the second grievance of the petition weak a leg to stand upon. Paragraph. Learned counsel for the state respondents seeks to submit the documents, seeks to produce the documents submitted by the petitioner and Shopon Kumar Shaha, private respondent number 6. In connection with the experience, in connection with their experience running a bus.
One is seeks to produce the documents of experience as submitted before the authority at the time of consideration.
Otherwise, the authority cannot produce.
Is that right?
The authority will produce.
That is the part of the
unless it is submitted, it cannot be produced.
Yes.
Submitted by the petitioner, submitted by. I have stated that. Paragraph, let the matter appear under the same heading. When will you come back? 10th May? 10th May?
Yes, madam, 10th May. Or in 13th May also,
13th?
because 10th May already you also fixed up certain matters.
Want to come back on 13th? 13th. No, no. What about the other matter?
Next matter also.
I'll pass the same order in the next matter.
In respect of Sudip Kundu only.
Serial number.
No, but I have to record that no vehicle has been.
Yes. No vehicle has been offered
Serial
as
number
it
5.
appears from the broadsheet.
Serial number 5.
13th May.
In the broadsheet.
হতে পারে কত বেড়া থেকে
Yes.
মানে 30
Additional report.
30 কি হলো?
না রেকর্ড আনতে বলুন।
হ্যাঁ হ্যাঁ
Well, may I just one thing? Well, 13th May, in the first matter, well, I shall produce the record in respect of this.
These two persons.
These two, no further report.
Showing experience.
Yes, yes, only record.
Should come by way of an affidavit.
No, my lord, I think affidavit.
That will be better. Again, it will be challenged otherwise. Let there be an affidavit.
No, my lord can go through the record also.
No, but I think it should be on record. What a by way of an affidavit. Produce by way of an affidavit.
Can you also see additional report given by Mr. Debray, page 11. They are also page 11. Types of vehicle offered is blank.
The actual manner, what's it?
Where education qualification.
Maybe that is left out.
No, left out.
That is left out.
So here also education is the first part.
First part.
Well,
I was going to omit that portion.
that portion omitted, because we are all considering that is not correct. Very well. Now your lordship kindly come to this Sudip Kundu, serial number 5. Here the type of bus offered for blank.
My submission is, my lord, after obtaining offer letter.
Maybe.
My lord, the petitioner will place vehicle of a BS4 BS norms vehicle.
No. Nothing is recorded.
Let this be dealt with on the next date because there are certain differences in both the matters.
Yes.
The experience part is also different. Here it's 11. It shows 11 years of experience, and this person has.
Sudip Kundu 11 years experience is Mr. Sen's report also.
And he has obtained higher marks than in the earlier matter.
Serial number.
No. Your
Then serial number.
education.
Excluded.
If you lordship exclude that, then it is all right.
This should not resolve on particular date. Same date, lordship can fix that.
So why don't you file a fresh broadsheet excluding the educational qualification?
Just যেটা আমি করে দিলাম.
Including the record.
Including the records, yes. So let me just record that
He will also place the record in respect of serial number 5. Sudip Kundu.
কিভাবে আমি এটা করে দিচ্ছি ওইটা যদি বাদ দাও এডুকেশন কোয়ালিফিকেশন তাহলে কি হতে পারে
সেটাই আমি এক্সেপশনে দিয়েছি।
হ্যাঁ
সেটাই আপনি দিয়েছেন। সেটাই
আমি তোমার দিকে দিই
আপনি আপনার দেওয়ার আগেই আমি
Let me not record the facts in this case because it will differ from the other fact. I'll just record your submission that you want to come back with the relevant documents.
Relevant documents. Yes.
And please exclude this educational qualification part in the, yes. Heard learned counsel for the parties. Paragraph learned counsel for the state respondents seeks to submit a
fresh report. You will also indicate says fresh.
Why is this additional? Where is the original? The first report? Why is it additional report?
Initially,
No. Initially, they have filed one report which was not accepted by this honorable court.
And that is not in record. That is not on record.
Maybe.
only one acting report দিয়েছি।
Seeks to submit a further report in the form of affidavit annexing the broadsheet upon exclusion of the column educational qualification and other relevant documents pertaining to the petitioner.
What is the petition?
Only petition.
The same date. Let the matter appear under the same heading or no the same date. Please serve an advance copy if you can.
30.
30.
30. দিদি সব নাম ধাম দিয়ে দাও
আমারটা